can't nail them.
Send out a text message again and an email.
We can. The fight has to be taken to them. Let's take another major one. I don't know. There was a film years ago.
Hey there, it's Jordan. Status Coup. We are live outside a New York City courthouse where right now, as I'm speaking, Stephen Donzinger, the human rights attorney, is inside in his sentencing hearing where he either will be freed after 2 years under house arrest or potentially sent to prison for 6 months. We were live about 20 minutes, half hour ago from a pretty large rally here in right outside the courthouse. There was well over 100 people here rallying for Stephen Donzinger before he went in for his sentencing. A lot of those people have went inside to the courthouse to watch the proceedings. We stayed outside because we can't bring our equipment inside. So I'm going to update you as much as I can on what's going on in there. I'm following it basically by Twitter to tell you the latest. But again, right now, Stephen's sentencing hearing is going on where he could be freed or could be sentenced to as much as 6 months in prison. There's also speeches going on out here. So I'll show you a little bit of this speech, and maybe then we'll do some interviews.
Shareholders and the creditors. Now, if this is a power struggle, you have to say, well, where does power come from? It comes from organized concentrations of people, and many people struggle organizing people. Now, you know how hard it can be to get just a dozen people thinking and moving in the same direction. Anybody that's organized a wedding or a birthday party knows that. Well, we're talking about organizing masses of people. Okay, so that's the job. Now, where does the other source of power gravitates towards? It gravitates and emanates from money, organized concentrations of money. So if I tell you to take on a big creditor of Chevron, okay, you say, why would you tell us to take on somebody that's as big or even bigger than Chevron? They're more powerful, and I'm going to tell you why. Because we learned with a corporate campaign concept how to break power down into manageable units that you can challenge, attack, divide, and conquer. So if I take on, for example, State Farm, or I take on J.P. Morgan Chase around the Chevron issue, or I take on the New York State Common Retirement Fund where public employees hold hundreds of millions of dollars in Chevron stocks and bonds, when I take them on and try to break them to exert enormous pressure on Chevron, okay?
So just to give you an update, right now inside the courthouse, attorneys for Stephen Donzinger, Ron Kuby, who's a really, really well-known attorney here in New York City, he is basically pressing to the judge Stephen Donzinger's long human rights record, his well-respected legal record, the endless amount of letters and support that has come in from fellow legal scholars, Nobel laureates, and so that right now they are basically pointing out Stephen Donzinger's character and long track record of human rights and legal work. Again, if you don't know this story, this has really been one corrupt cesspool from the beginning. A New York federal prosecutor declined to prosecute or go after Stephen Donzinger because the case was so flimsy. Stephen Donzinger had successfully, along with others, prosecuted Chevron in Ecuador for poisoning the Amazon there. They drew a $9 billion settlement that Chevron had to pay for poisoning the Ecuador Amazon. Of course, Chevron refused to pay it and instead has gone on a corporate crusade against Stephen Donzinger, although a New York prosecutor refused to prosecute Stephen Donzinger because there was no case. The judge did a very, very extraordinary, unusual thing, and he hired an outside private prosecutor to prosecute Stephen Donzinger. That prosecutor has ties to Chevron through the Federalist Society, and there are two judges in this case that have direct ties to the Federalist Society and Chevron, who have prosecuted Stephen Donziger. Stephen Donziger was not afforded a jury trial. The longest house arrest for an attorney in New York City ever was 90 days. Stephen Donziger has now been under house arrest for 270 days, so over 2 years. And what he might be charged on today, well, he's already been charged, but what he might be sent to prison for today is a misdemeanor charge of contempt of court for refusing to hand over his laptops, phones, devices, which have attorney-client privilege on it, which, if you know the law, attorney-client privilege is pretty sacrosanct. There are legal provisions to protect attorney-client privilege so that clients' and attorneys' communications is private and can't be used in investigations, trials, whatnot. So, of course, Stephen Donziger wasn't going to hand those over, and that is what he was charged with, contempt of court, by these Chevron-friendly judges.
780.
Yeah. So I said... What's that?
You said a lower number.
Oh, no. The longest a New York City attorney before Stephen Donziger had been in was 90 days. Stephen Donziger has been in there for 270 days. Oh, 700. Yeah, you're right. 720 days. 80 days. 780 days. So it's extremely, really unbelievable we're at this point. I'm still reading updates that are going on during the sentencing. Again, they're basically giving character witnesses for Stephen Donziger. I still haven't heard from this judge what the crime is. In the very, very long, I think it was a 145-page indictment of Stephen Donziger. Over the summer, the judge said for Stephen Donziger it was time to pay the piper, even though he had already served an insane amount of days under house arrest. Hold on.
I tell you this, I exercise a lot, I watch my diet, I want to live a long time, all right? So I'm now probably looking right here, but I'm now 77, and believe me, I got...
I'm just reading from, read it. By the way, smash the like button, share this live stream. The Ecuadorian people...
That's great. Anybody else? Is there somebody else who would like to come up here?
So right now, Stephen Donziger's attorney is still basically reading out that this is unprecedented, what has happened to Stephen Donziger. Ron Kuby, his lawyer, just said, quote, "No matter who you are, you could start your career on a case against us and end your career on the same case, and you will never win. We will outlast you." So he's talking about Chevron's intimidation and all-out crusade against people like Stephen Donziger. The people speaking right now have been out for Stephen Donziger at repeated protests. Before Stephen Donziger went in for the sentencing, there was well over 100 people out here. And Roger Waters of Pink Floyd spoke. An 11-year-old activist spoke very eloquently and beautifully on behalf of Stephen Donziger, basically making the point, why isn't it Chevron that was under house arrest? Why was it the human rights attorney who prosecuted them for poisoning the Ecuador? And by the way, when we talk about poisoning the Ecuador, and obviously I've been covering Flint and that poisoning here in America for many years, people died. People got all sorts of cancers. They either died, people became sick. And by the way, the Amazon and Ecuadorian, these are indigenous people in Ecuador, are still under attack from oil extraction, drilling, and whatnot, and the dumping of that waste into their drinking water there in Ecuador and throughout the world. So this isn't something in the long distance. This is something that's still going on. Let's hear a little bit from the current speaker.
They had Sam Nunn, former U.S. Senator from Georgia. From 1997, when he left the Senate, he was on the board of Chevron and Coca-Cola until just a couple of years ago. Then there was another executive vice president, one of the 5 top officers, also on the board of Chevron and Coca-Cola, okay? Then you've got, right now, you've got a board member. How many of you, by the way, and I hope I don't see any hands go up, because it's not good for you. I'm a vegetarian also, barely vegan. But how many of you ever eat a McDonald's hamburger or a French fry? Anybody here? Oh, we got one over there. We got one. Okay. I have eaten some of the French fries. Okay, but not anymore. One of the top people at McDonald's is on the board of Chevron. Yep. And guess what? McDonald's has its own separate entity within the Coca-Cola company. Okay? So that's a major link right there even now. All right? So you get a little idea of maybe where we might be going with these things. But remember, I'll say it again. You cannot confront powerful corporate and political entities and expect to gain any meaningful concessions or justice unless you are backed by significant force of power yourself. A real, and I say real, corporate campaign is a mechanism to confront power with power. And that's what it's going to take to bring Chevron down. And Stephen Donzinger and the lawyers that have worked with him, going back to 1993, and all the people like yourselves and people that were out here, you have laid such a strong foundation, okay, such a strong foundation that so much work has already been done that'll make a corporate campaign much more successful. We just need to take all the wonderful things that have been done and turn it into...
So I just want to update you on what's going on there inside. Ron Kuby, who is Stephen Donziger's attorney, is saying the Department of Justice's claim that it lacked the resources to prosecute Donziger can't be true because the government has tremendous resources. Judge Cap picked this court, so he's talking about this Chevron, one of the judges, the beginning judge, Judge Kaplan, quote, picked this court. Come on, Judge, how does this look? How does this promote respect for law? Kuby is asking the judge inside of there, Judge Loretta Preska. Kuby continues, the world has taken notice. The world has taken notice. The court worked hard to cap the tribal issues closely to the charges. Now you have the United Nations Working Group report. There are journalists, writers, scholars who are paying attention. So the attorney, Ron Kuby, is trying to press on Judge Loretta Preska that the whole world is watching. The United Nations has called, the United Nations, by the way, five international jurists have demanded that Donziger be freed and paid compensation for his house arrest and loss of income for these 780 days he's been under house arrest. And by the way, I just interviewed him in, you can turn it to me. I just interviewed him in his New York City apartment the other day. Listen, I'm no psychologist, but I was during COVID in New York City, I was going crazy living in a tiny apartment, and I could walk. I could leave the apartment to take a walk. He can't do that. For 780 days, he has only been able to go out for a medical appointment or here and there for things for his teenage son. I wanted to speak with you if I can. Sure. You and I at the last rally for Stephen Donziger. Give the audience your name again.
Yeah, I'm Michael White. People may remember me occasionally as a co-founder of Citizens Defending Libraries. So this is obviously about environmental degradation and at the hands of the oil companies, and we know what's happening in terms of climate change and all of that destruction, but this is also about the injustice of who is suffering the most. But it's also about censorship. So Citizens Defending Libraries, we've been paying a lot of attention to the shutdown of the libraries as a way of shutting down information. This is about shutting down information because people should know what's going on with what the oil companies are doing to the environment. It's also about privatization, the privatization of everything. So you've got the Amazon. Basically, Chevron has been treating the Amazon as if they own it, as if it's their private property. But here we have also the privatization of our court system. Chevron is basically in possession, owning the courts. Then it was really apparent when our bake sale young lady, the 11-year-old or whatever she is, gave her speech, how the media is not covering this. The privatization of the courts should be a major story, just like the Julian Assange being locked up as an example. Stephen Donzinger is being locked up, setting an example so that nobody, I'm a lawyer, actually, and I have an urban planning degree, and I might have gone into environmental law. I might have been doing this, but if I were a young lawyer, I would say, no, they'll do to me what they're doing to Stephen Donziger, because the corporations now own the courts, and the media is not reporting it, because the media is privatized and owned, so we don't hear it. So we have to rely on you, Jordan, and Status Coup, and a few outlets. But you're operating through the internet, and the internet is subject to suppression. So I think right after the last time we talked, you were covering the environmental in Washington, the demonstrations in D.C., and you had your feeds taken down. You lost 2 hours of Status Coup product. So that's the kind of thing that can happen. So what we're witnessing is the privatization of everything. And it was pointed out to us during one of the speakers said that over here, Judge Preska, Loretta Preska, who is the Chevron-owned judge, has her name on the building. It says the Loretta A. Preska entrance on this federal court building. It should say this is the Chevron entrance.
And you know what? And by the way, I'm not trying to be rude while he talks. I'm just looking for updates. What's amazing to me, and I'm a lawyer, but I know enough. I mean, just one thing after another, he wasn't afforded a jury or any type of trial. The fact that, I mean, I've never heard of a prosecutor, a federal prosecutor, refusing to take this case, and then the judge basically offshores it to a private prosecutor who has ties to the Federalist Society, which is funded by Chevron. So all around, he wasn't afforded a jury. The longest a human rights attorney or any attorney has been under house arrest in New York was 90 days. He's been under house arrest for 780 days, which is over 200 years. No jury, just one thing after the other. And
three of his birthdays under house arrest now.
Right.
3 consecutive birthdays.
Right. And by the way, the original, the most glaring thing about this, okay, from the beginning, Donzinger and people he was working with won a $9 billion settlement. Instead of paying it, Chevron came up with this cockamamie thing that Stephen Donzinger paid off an Ecuadorian judge for that conviction, or for that ruling against Chevron. The only witness that Chevron had was this judge, who they paid a lot of money for him and his family to come over to the United States, and then they peppered him 53 times, 53 different times. They basically trained him on what to say, and essentially gave him a script on what to say, and eventually it came out that he was lying. So basically the original thing that Chevron, in refusing to prosecute, refusing to pay the $9 billion settlement, they came up with this, basically a RICO charge against the human rights attorney who never even had a bar complaint, which there is no evidence for, and that is fundamentally what has been the domino for everything else. I mean, it just seems like a Banana Republic type of charade going on, and you made a key point. I've seen no media coverage. Democracy Now!, independent outlets here and there. I mean, we've covered it as much as we can. The New York Times is right here. They covered it back in 2011, 2014, when this began, but they haven't covered it as he's been under house arrest, as there's been these protests, as Nobel laureates have come out, 67 legal scholars, and I mean, the New York
Times lawyers who are working to prosecute Donziger for Chevron. So, but I think,
to be clear, one of the New York Times leading lawyers works for the law firm that is prosecuting Donziger.
I mean, this is an extreme example of injustice, and the fact that it's not being covered, the fact that it's not at all, he's being made an example. Message to everybody you can't take on the corporations, or at least if you take on the corporations, you're not supposed to win, which is the reason that they're making an example of him, because he won. He won for the Ecuadorian people. He won billions of dollars. That money should be paid. But instead, it was like Julian Assange, and people know that this is going on, and they know that it's not being covered, and the non-coverage is an example as well. It's the media telling us that other people are in charge.
And just to update you what's going on in there, Donziger's attorney, Ron Kuby, he responds to the possibility of probation. It's, quote, it's a spectacularly bad idea. He has already had 2 years of supervision. There's no need to help Donziger create an environment that will prevent reoffending. Kuby, there is no danger of reoffending because Donziger has been disbarred. Again, that's a key thing. A human rights attorney who's done amazing work basically for 20 to 30 years has been disbarred over, I can't tell you what. I can't tell you. And by the way, Stephen has said this. I have said this. Obviously, today is about Stephen Donziger, but this is way, way bigger than Stephen Donziger, and it goes back, you're talking 10 to 15 years. There has been this creeping propaganda narrative of eco-terrorism in this country. Indigenous people, black people, brown people, poor white people, for the crime of protesting toxic shithole, toxic ticking time bombs, frack gas, crude oil, mines that have been native land. You're talking, even look in Utah, they tried to basically cut Bears Ears, which is a native monument, by 85% under the Trump administration. And the people that protest this have basically been criminalized. There have been laws set up in Republican states to basically criminalize protesters of these pipelines, of fossil fuel projects, where essentially they have made it where if you ran over a protester with your car, you would not be held liable. They have made it that if you protest crucial infrastructure, I think it's called, you would be facing felony charges, 5 years in prison in some cases, just for protesting near a construction site for a fossil fuel project. And I can tell you from Standing Rock, I got the PTSD to tell you. I mean, that was the definition of fascism. You had an army of police out there that we pay for, out there protecting not people, but an oil company. And by the way, the federal government then paid back the police department for brutalizing the Native Americans. The Trump administration paid back the North Dakota Police Department. I mean, you're talking, I think it was $10 to $15 million. $10 to $15 million for tossing grenades at indigenous people, freezing water, rubber bullets at point-blank range. I saw someone almost have his scalp ripped off at Standing Rock with a rubber bullet, point-blank range, the pepper spray, the mace, all of that. And we're seeing it at Line 3, which, sadly enough, is now going into operation. You had essentially, the news came out, that they were using, police were using torture mechanisms on the indigenous and non-indigenous water protectors that were protesting Line 3 in really, really brutally cold temperatures in the winter during a pandemic. So this is not just about Stephen Donziger. This is about, they are basically cracking down on any dissent to prop up the fossil fuckers on their last stand.
The water protectors were being attacked by police that, as you say, we are paying for as taxpayers. But you've got oil companies also additional those police forces so that they are privatized. And it's not just police that are out there. You've also got the this privatized paramilitary people out there, companies. Once upon a time, the militaries were supposed to be run by countries and accountable to people. Now we've got private military forces that are hired out around the world, but even in this country, to attack the water protecting protesters. They go around without license plates. They go around without ID. They set up roadblocks. I said before, we're experiencing the privatization of everything. It comes with inequality, so you have these huge shift of resources to just a few people, and they use those resources to own everything.
And they're still going back and forth, Donziger and the judge. By the way, I'm not telling you to. I read it. If you read this 145-page indictment from this judge, which he so accurately said her name is on this building, if you read this indictment, I mean, this is not a judge. It's just teeming throughout the indictment with scorn against Stephen Donziger. She said, oh, it's time for him to pay the piper, and that he has, I'm paraphrasing, not this term, but basically alluding that he has made some type of mockery of the legal system. And again, one has to ask, the purpose of all of this, right? The purpose of what Chevron is doing, the purpose of what Energy Transfer Partners was doing in Standing Rock, the purpose of what Enbridge has done in Line 3, the purpose of the media who just totally blacks it all out, is to completely change the subject from the fact that Chevron, to save, I think Stephen said $3 a barrel of oil that they dumped into the Amazon in Ecuador, that totally changed the subject from the fact that Chevron has killed people. That's what this is. They have changed the subject to talk about semantics and technicalities and legal statutes and all this legal jargon of what Stephen Donziger did or didn't do. But there's no discussion. Chevron's not in court criminally. No oil company is in court criminally when they have poisoned people, when they've killed people, when they have given people at young ages cancer. And by the way, the Dakota Access Pipeline has been operating for years. That spilled a whole lot of times. And these oil companies are notorious, particularly in Texas and North Dakota, for never reporting the oil spills. So we have no fucking idea, frankly, how often Dakota Access Pipeline has spilled, whether it has already spilled underneath the Missouri River, which was the biggest scare of those Native Americans at Standing Rock. The pipeline, it's 90 feet under the ground, under high-tech, state-of-the-art equipment. It can't leak. Well, we know it's already leaked. The press reported it as 5 times. I would probably say it's a lot more than that. Enbridge, which is the owner of the Line 3 pipeline that just went in, is responsible for the largest oil spill in American history in Kalamazoo, Michigan. So this is just one thing after the other, after the other, after the other. And, the energy outside here was really, really good when Stephen was outside here before his sentencing. And this isn't going to change because Biden, by the way, who, ran on, we're going to stop drilling on public lands, like that was enough. That's not enough in the first place. He's moonwalked away from that. Just like he moonwalked away from the $15 minimum wage, just like he moonwalked away from a public option, just like he's moonwalked away pretty much from anything because he's a Republican. He's not Trump. Great. And I want to make another point. I'd like your thoughts. While Trump was in there, you had the resistance, aghast at the brazen attack on the rule of law. Biden, Pelosi, Schumer, all of them. Corporate Democrats, the Twitter people that, said it doesn't matter who runs, vote him in, get rid of Trump. They're quiet as a mouse on this. Let's not forget Julian Assange. Jesus Christ, in a normal world, I think 5 days ago, there was a mega story. I was shocked. It came from a corporate news outlet. But Yahoo News broke a massive story on Julian Assange showing that the CIA plotted to kidnap and assassinate him. Aside from a segment, I think I saw 2 segments on it, on the news. That was it. So they literally tried to assassinate him because the CIA was so pissed off and embarrassed that WikiLeaks had gotten essentially released through Vault 7 the CIA's hacking mechanisms. So the government has plotted to kidnap and assassinate a man that they are now politically torturing in the UK. That's got no coverage. This is getting no coverage. So you have to ask yourself, I think at this point, it's clear we're living under a fascist system.
Well, that story was an update of what Max Blumenthal and others had originally reported about the spying on Julian Assange and just how far they were willing to go. I'm not sure why it suddenly got reported by Yahoo News by Michael Itzikoff, who's was a big Russiagator and is not terribly reliable. He inserted into this story the idea that the Russians were going to collaborate to help Julian Assange escape. That's what our intelligence agencies said. That might be his job at this point. But when the story was
also in that story, importantly enough, they said that the CIA couldn't find evidence that Julian Assange and WikiLeaks were working with the Russians.
Right. But that story, Democracy Now! Did not report that story when Max Blumenthal. Max Blumenthal has not been on Democracy Now! With any of his important reporting since 2014. That was the last time he was on. So there's a lot of important news that is not getting out. Now this is finally getting out, and it should be grounds for releasing Julian Assange. But as you were saying, everything's inverted. So the people who have committed crimes are Enron, poisoning people in the Amazon. Julian Assange was reporting the war crimes, and he's the one who's prosecuted. Daniel Hale reveals that war crimes are going on, and he's the one who's prosecuted and put in prison. So we keep getting this inversion so that the people who are committing crimes can continue to commit the crimes. We have to lock up the people who are telling you about it.
Tell people again your organization.
I'm a co-founder of Citizens Defending Libraries. So we were founded in 2013 when we were able to connect the dots about how the New York City public libraries were being sold off as real estate deals. And really there's a convergence of a lot of interests that are interested in getting rid of the libraries, getting rid of the books, pushing people to the internet, making sure that you don't get any information unless you're doing it in a way that can be picked up and surveilled. So we've been doing that. We've had some successes, but it's a hard fight. I also write Notice in New York about development in New York, and National Notice about issues like these.
And your name again?
Michael White. Michael D.D. White, because there are many Michael Whites. In fact, I know how the economy is going generally, because when the economy is not going very well, I get a lot of phone calls about the Michael Whites who have defaulted on their credit cards.
Thanks, Ben. I appreciate it. So that was just one person who's been out here speaking out. I want to just give me a minute, smash that like button, share this live stream. I want to make sure I haven't missed anything as this continues to go on inside. Again, the sentencing for Stephen Donzinger has been going on inside. Let's see. So right now it looks like it's heading towards a decision. Stephen Donziger's attorney says, quote, "It's up to the court whether you want to make Stephen a larger martyr than he already is." Donziger's going to speak. I think he's speaking right now, actually. So it seems like they're getting closer to a sentencing. So obviously I'm updating you as best as I can while I'm live. Hold on. I was looking for. How you doing? Hey there. Can I have you on? So again, I'm going to just try to update you as best I can, but I wanted to talk to you because I heard you speaking. Can you tell the audience your name and why you're so passionate about this?
Absolutely. So my name is Christopher Espinoza. I'm passionate about this because, first off, I'm Ecuadorian. I'm a community organizer, and anytime any atrocity like this happens anywhere, whether it's in Ecuador, whether it's in anywhere, any place in the world, we need to step up, especially living here in the U.S.
I think for the U.S., hell, I've been covering Flint and that poisoning, and half the country doesn't know or give a shit. So double that. for the atrocities going on in places like Ecuador and other countries. Can you talk about, for the audience, we know that Stephen successfully prosecuted Chevron, but this isn't something that happened long ago and it's just over. People have been killed, people are still sick, and they're still trying to oil drill things in Ecuador and other countries.
Yes. Wait, so what was your question?
Basically, this isn't something that's over for the Ecuadorian people.
No, it's not something that's over. The trauma is it's going to be generational. There were people that were affected by the oil drilling, and these are scars that people are going to have to live with. And anytime we have big corporations do something like that, they haven't been held responsible in doing the proper cleanup and paying these penalties. And they have the money to do so. They just don't. They rather engage in this witch hunt against an attorney who's really doing a good job for the people, and that's where we are right now.
What does it say to you that we heard all of this chatter while Trump was president? Trump and his Department of Justice is attacking the rule of law. I don't know. I don't really hear the media covering this at all. Just like Julian Assange and other things. It seems that once Trump is out, if Biden Democrats basically allow things like this to go on, because there's been Congress people that have asked the general to drop this, but you don't really hear anything much from the media or the Democrats on Stephen Donziger.
I think we have different types of Democrats. We have progressives and then we have Democrats, establishment, and so forth. But besides that point, even though we do have a majority of Democrats in the Senate and in the House, there are still policies, progressive policies, that aren't getting passed. There's a reason for that, and I'm sure we all know at this point, special interests and big corporations, they have a big stake and a voice in these issues and how government with it. A lot of the work that we really want to see and that I engage myself is that we want to see good government, and we want government to really work for the people, which is what government is supposed to do, and not function, not have a framework, not function to protect wealth and to protect, those people at the top.
Let me ask you the wider picture, because this isn't just about Donziger. We saw what went on at Standing Rock. We're seeing what has been going on at Line 3, which now is operational, the pipeline, and flowing that oil. There's going to be other pipelines dumped on Native American land through reservations. There's going to be other scenes where we see Department of Homeland Security helicopters flying over protesters, which we saw on Line 3. It just seems to me all of this talk from the government about climate change, but they're just allowing these pipelines and, frankly, the criminalization of protests to happen throughout the country.
Yeah, that unfortunately it happens a lot with every single event that you mentioned, with rock and so forth, and essentially that's the time that we live in right now. And our police force, our law enforcement, they're criminalizing people who really just want government to do what is right.
What's your name again?
Christopher Espinoza.
Thank you. And show your sign. So you have Chevron, ecocide, racism, greed, and it's kind of over a lot of articles about all that. So thank you. Appreciate it. So the sentence is still on. Let me make sure. I haven't missed anything. Hold on. All right, so now Stephen Donziger is speaking. So let me read. Quote, I stand before you for sentencing after a misdemeanor trial where I was denied a jury after being attacked by Chevron for years for helping people in Ecuador to culture, lives, and our planet. That's the context for why we are here today. It helps the court understand my character and motivations. I quote, I accept full responsibility for all of my actions that led to this moment. Ultimately, the appellate courts will decide whether what I did was entirely ethical and appropriate or was a crime. I chose to go into voluntary civil contempt in order to get appellate review of orders that would destroy my client's attorney-client privilege. No lawyer has ever been prosecuted for such a course of action. Who ruled that my detention violates international law? So that he's talking about United Nations 5-panel judge of international jurists just ruled that Donzinger's detention has been illegal and that he is owed compensation for 780 days under house arrest. Obviously, he's been disbarred, by the way, which is another ridiculous, shameful thing. So obviously loss of income. He's got a 15-year-old kid. So Donzinger is basically speaking up. I think the key thing that he said to me is he was denied a jury. I mean, I really don't get that. I'm not a lawyer. It just defies logic. If somebody's going to be under house arrest for 2 years, I mean, you would think that's for a serious violation, right?
I'm putting it live inside the court. I'm showing what I can through my phone with
I don't know.
the loudspeaker live in the court if anybody wants to hear it live.
So let's see if we can pick up the audio here. I doubt it.
My sister, Susan Sherman.
Yeah, I don't think you're going to be able to. What do you think?
Yeah, I can hear it.
Okay.
Stephen is speaking now.
My parents are my wife and son, just so you know, don't like the public eye. My son just started his 3rd straight year of school. First year of high school. With his father wearing a large ankle bracelet. Unable to travel. Leave his home except under court supervision with permission, usually given 48 hours in advance. Unable to go out for dinner. Unable to have a father capable of doing all the things a normal father can do and should do with a child, including act with spontaneity. Like wake up and say, hey, it's beautiful out. Let's drive over to Jersey and go watch the Giants. Can't do that. Or it's late at night after dinner, we can't walk across the street to get an ice cream at Ben and Jerry's or go for a run. Beautiful weather. I have an ankle bracelet. I can't run with an ankle bracelet, although I've tried. And I don't have permission anyway, so we can't really do that kind of thing. And if I could tell you the times that it's happened over these past 2 years and 2 months, the look of disappointment on the face of a child, it hurts. That's exacted a cost on me, more importantly Matthew, also my wife, who has to witness it, and is also obviously a part of it. So I ask, if nothing else, that you give as much value as you can when determining my sentence to my relationship to my son, as he has suffered quietly for a good 15% of his life as a collateral consequence of arrest. Final point. And this has to do with me. any of them pre-trial or pre-conviction. As I understand it, no lawyer in New York for my level of offense ever served more than 90 days in a sentence, and that was under home confinement. My home confinement is now more than 8 times that amount. As Mr. Kuby pointed out, I've been disbarred. By the way, I never had a hearing where I could challenge the facts that were used to disbar me. As a result, I'm unable to earn income in my profession. I have no passport, as you know. I can't travel. I can't do the human rights work that I believe I'm reasonably good at. Can't go to Ecuador. Where people depend on me. In addition, and this is little known, Judge Kaplan imposed millions and millions of dollars of fines and court costs on me without a jury. And there's still a pending motion, I believe, for $32 million against me to reimburse Chevron for its legal fees, or some of its legal fees in the RICO case. I was never a man of great means. We live in a 2-bedroom apartment. I have no money. I mean, I think I have a potential to earn money, but right now, I don't have a bank account. So I ask you, humbly, might that be enough punishment already for this level of offense? Almost done.
Take your time, sir.
I want you to know, respect the rule of law. I try to adhere to the rule of law. I'll continue trying my best to do that as we return to the side. I would ask that you agree to let the appellate court do its work in this case, that any residual issues around computers and some of these orders be worked through on the civil side. And I would ask that you, as a result of everything I've said, allow me to go home today without an ankle bracelet and sentence me to time served. Thank you.
Thank you, sir. Special prosecutors wish to be heard.
Yes, Your Honor. With respect to some of the comments made by defense counsel, I feel compelled to respond. I don't agree with Mr. Kuby's recitation and characterization of the history and the background of this particular case. There is a 497-page opinion. It is a docket entry 1874 in Chevron Corp. Versus Donziger. And in that decision, Judge Kaplan, in great detail, went through the evidence of Mr. Donziger's actions in engaging in fraud and corruption to obtain a $9.5 billion verdict in Ecuador.
The proof is in the crude
And Judge Kaplan's findings that that verdict was the direct result of a series, a parade of corrupt acts by Mr. Donziger and co-conspirators in Ecuador.
Based on paid-off witnesses.
Judge Kaplan's decision and the findings were affirmed by the Second Circuit on appeal.
Yeah, 2 million to be exact.
In the Second Circuit's opinion,
Absolutely.
the Circuit specifically noted the absence of any challenge by Mr. Donziger to the factual findings in the 495-page opinion detailing Mr. Donziger's and his co-conspirators' acts of corruption. So I disagree with any characterization
Work for Chevron's
background and how it got here. With respect to defense counsel's characterization regarding the post-judgment discovery proceedings, I also know how they have been characterized. Following Judge Kaplan's
Not to mention, she's
2014,
Governor Cuomo's lawyer.
Judge Kaplan issued a judgment so that Mr. Donziger would never be able to profit from the judgment he attained in Ecuador through fraud and corruption. There was a court order prohibiting him from engaging in certain activities and a court order directing him to do certain things, such as to assign his interest in the judgment, his interest to hundreds of million dollars that he personally would obtain. Mr. Donziger, starting in 2014, and as the evidence demonstrated at trial, did not comply with that order, and he did so deliberately. He did not have his interest in the judgment.
He didn't want to give his devices away.
By 18, after the Supreme Court denied certiorari, after the Supreme Court of the United States declined to hear any appeal from the Second Circuit's affirmance of Judge Kaplan's lengthy decision, Chevron had obtained evidence and knew, of course, that Mr. Donziger had not been complying with the judgment, didn't assign his interest in the RICO judgment. They moved to hold Mr. Donziger in contempt, as was their right, and as they should have. Judge Kaplan authorized discovery not on the sole issue that Mr. Kuby spoke about, which was Mr. Donziger's fundraising activities. That wasn't what the post-judgment proceedings were solely about. They were also about whether Mr. Donziger was violating Judge Kaplan's judgment from 2014 in other ways, like selling his own interest in the judgment and monetizing it. And it turned out he was. There was also discovery because Chevron was entitled to collect on the money judgment from the RICO case.
There was also discovery of
$800,000. Discovery was not limited to that Mr. Donziger says he was challenging on appeal. There were other issues. And what happened during those post-judgment proceedings is that Mr. Donziger began violating court orders almost immediately. Court orders that weren't even charged in the criminal contempt case. He was ordered to produce documents. He wouldn't produce them. He withheld them on First Amendment grounds. Judge Kaplan said, First Amendment doesn't apply here. No, you have to turn them over. He still didn't turn them over. This went on for months. With Mr. Donziger refusing to answer questions at deposition, with Mr. Donziger admitting that he had withheld hundreds of documents, and I might add, as we sit here today, Mr. Donziger still has to produce documents that he was required to produce, claiming that he has a right not to produce them. Mr. Donziger got where he is today after many, many months of refusing to comply with court orders.
2 years.
He never provided a privilege log. He was unnoticed that he had to. He was withholding documents on unspecified privilege grounds. And Mr. Donziger knew already happened to him once in the civil case, that if you don't produce a privilege log, you will be deemed to have waived privilege. He already went through that. That happened years earlier, but he did it again. And so Judge Kaplan did what he had done before and what the local rules provide for in the Second Circuit is that can happen, which is you end up waiving privilege. And still Mr. Donziger refused to produce documents. Mr. Donziger did not appeal. He did not appeal Judge Kaplan's order directing him to surrender his computer for imaging. Never challenged that on appeal. So any claim that Mr. Donziger had gone a route of challenging Judge Kaplan's orders on appeal and then get charged with civil contempt is not accurate. The orders for which Mr. Donziger was charged with criminal contempt, he did not appeal to the Second Circuit. Mr. Donziger was charged only after Judge Kaplan had tried coercive fines to no avail, ordered him to surrender his passport to get him to comply to no avail, and Judge Kaplan actually gave Mr. Donziger an opportunity. What he said to him was, Mr. Donziger, look, if you get your appellate brief in by X date, you don't oppose any expedited appeal, I will suspend the portion of my order that would disclose to Chevron any of the privileged information. Mr. Donziger didn't take him up on it. He didn't even say, Judge Kaplan, I can't get my brief in by that date. Can I have a little bit longer? But, and I will surrender the computers for imaging, but the images will just stay with the forensic expert. The full record of this case is public. There are transcripts. There are numerous court filings.
Yeah, including the bribe.
I urge everyone to read the actual underlying record, just as I urge the UN Working Group to do so. Because what has been characterized today, and I have seen in other forums by Mr. Donziger, is just simply a mischaracterization of what has happened. The best authority is primary source authority. Read what actually happened. Read what actually was appealed.
Yeah. Puppeteered by
Mr. Donziger knew what he was doing each step of the way. His conduct was not appropriate, and it most certainly was not ethical. It is unethical for attorneys.
Unethical is the environmental destruction and the 2,000 lives that have been lost. That's what's unethical.
It simply is.
And the people that are still dying with 1,000 oil pits in the Ecuadorian Amazon right now,
With respect to the claim that there is no attorney that has been sentenced to jail for misdemeanor contempt, criminal contempt, that is also not true. I refer the court to Rojas, R-O-J-A-S versus United States, 55 F. 3rd, 61. Second Circuit case, I think it is 1995, it is cited in my papers. 1995. That is an attorney here in the Southern District of New York, was sentenced to 3 months jail after a criminal contempt trial before Judge Duffy. There is another case of an attorney being sentenced to 3 months in jail in the Second Circuit. That is United States versus Agajanian, A-G-A-J-A-N-I-N. It is at 852 F. 2nd, 56, Second Circuit, 1988. Again, an attorney sentenced to forensically
Fossil fuel
inspect the
prisoner!
active criminal. With respect to the appropriate sentence for Mr. Donziger, Your Honor, as I stated in my papers, defer entirely to the court, and with that, I rest on my submission. Thank you. Anything further, Mr. Kuby? Thank you. Ladies and gentlemen, as I have said before, I recognize that the events giving rise to this criminal contempt case mark the latest chapter in a fierce, decades-long legal battle between Mr. Donziger and Chevron. But, as the court made clear in its findings of fact and conclusions of law, this case is wholly unconcerned with the debate regarding any responsibility Chevron might bear for the oil pollution in the Oriente region of the Ecuadorian Amazon. Instead, this case is about the rule of law, implicit in which is the fundamental principle that a party to a legal action must abide by court orders or risk criminal sanctions. Nothing more, nothing less. This is a principle equally applicable to all, the bad and the good alike. All are equal before the law. Mr. Donziger's pointing to the underlying Ecuadorian litigation does not change the facts that, following a lengthy trial, 1, Chevron won a judgment against him before Judge Kaplan. 2, that judgment was affirmed in its entirety by the Court of Appeals. And 3, the Supreme Court denied Mr. Donziger's cert petition. This case is not about relitigating the case in Ecuador or even about the merits of the civil proceedings before Judge Kaplan. It is only about Mr. Donziger's disobedience of Judge Kaplan's orders. That's it.
You already paid the price for that!
I'd like to note the well-known principle that the ends do not justify the means. It's clear from Mr. Donziger's comments today, and indeed from the record at trial, that Mr. Donziger does not regret what he did and he did not do before the proceedings before Judge Kaplan. I note that today Mr. Donziger told us that he accepted personal responsibility for his acts, but he expressed no remorse and still blamed his predicament on his advocacy, on Chevron, on Judge Kaplan, and the like. Mr. Donziger told us that he chose to go into voluntary civil contempt. Well, it has been made clear in the court's findings of fact and conclusions of law, a contemptor doesn't get to choose. If you go into contempt, you may be punished civilly or criminally. It's not your choice. Indeed, having shown no contrition, Mr. Donziger appears to consider the entire proceeding before Judge Kaplan to be illegitimate and stacked against him, despite the Court of Appeals decisions to the contrary. In Mr. Donziger's view, his client's cause is righteous, and Chevron is a behemoth trying to crush them.
Yes.
But let's get one thing straight. Even if Chevron is the bad guy in Mr. Donziger's eyes,
It is
that does not make Mr. Donziger the good guy. Mr. Donziger is not here because he took on Chevron on behalf of his clients.
Oh, okay.
Rather, he is here as a direct result of his own actions and inactions, his years-long defiance of Judge Kaplan's orders. To be entirely clear, the ends do not justify the means. A righteous cause does not afford Mr. Donziger an unfettered license to disregard lawful court orders that he doesn't like. To the contrary, quote, a lawyer of all people should know that in the face of a perceived injustice, one may not take the law into his own hands, close quote. Cutler, 58 F. 3rd at 840. In this country, the rule of law prevails. Since the founding, the government of the United States has been a government of laws. See Marbury versus Madison, 5 U.S., paren 1 Cranch, close paren 137, 163, paren 1803. And, quote, respect for judicial process is a small price to pay for the civilizing hand of the law, which alone can give abiding meaning to constitutional freedom, close quote. Walker v. City of Birmingham, 388 U.S. 307, 321, 1967. Just like everybody else, Mr. Donziger is not above the law. Any virtue of his client's cause does not excuse the fact that he has repeatedly ignored or outright defied Judge Kaplan's orders for the better part of a decade. This shows an astonishing lack of respect for the law and for the authority of the federal courts. And Mr. Donziger's, quote, conduct is particularly egregious in light of the fact that he is an attorney, close quote. United States v. Ware, number 04 Crim 1224-01, paren RWS,
Where was the law when all his
2008 Westlaw 520-3658, star 6, SDNY, December 9, 2008.
No evidence to show.
Now, a word about the costs incurred litigating this case. In his sentencing submission, Mr. Donziger refers to the taxpayer funds that have been expended relating to this prosecution. The court observes that those costs were almost surely driven higher by Mr. Donziger's filing repetitive motions seeking relief that the court had already denied. For a non-exhaustive list of examples, Mr. Donziger has filed no fewer than 5 motions to dismiss the charges, 3 motions to disqualify the special prosecutors, 5 motions to recuse the court, 5 motions seeking vast swaths of discovery to which he has no legal entitlement, and 6 motions seeking the elimination of the conditions of his pretrial release. Repeatedly, and in flagrant contravention of Local Civil Rule 6.3, those motions asserted contentions that the court had already rejected, many of them more than once. Yet, those repetitive motions necessitated responses from the special prosecutors, replies from Mr. Donziger, and the expenditure of court resources. The court acknowledges that Mr. Donziger has spent now 180 days subject to home confinement.
They better.
The majority of that time has been the result of Mr. Donziger's requests for adjournments due to issues relating to securing counsel to represent him. Trial in this matter was originally scheduled for June 15, 2020. That date was adjourned to September 9, 2020, due to the pandemic, a period of 86 days.
They use the pandemic as an excuse.
5:13-18. But every adjournment after that was granted at Mr. Donziger's request. Although the pandemic was ongoing throughout that period, thanks to the Herculean efforts on the part of the District Executive's Office and other court personnel, the Southern District of New York was able to conduct numerous trials during that time. In total, the trial in this case was adjourned at least 6 times. Those cases significantly delayed the case's resolution and have been the most direct cause of the length of Mr. Donziger's home confinement. Seeking to deflect blame for the delays, Mr. Donziger counters in his papers that all of the delays were due to the pandemic and the delays were the court's fault because, he says, the court could have forced his counsel, who said she was unprepared and unable to try the case, to proceed to trial in any event. Once trial finally was held, the court issued its findings and facts and conclusions of law within 1 week after the briefing was completed on Mr. Donziger's post-trial motions to dismiss. The blame for Mr. Donziger's lengthy home confinement lies squarely on his head. Now, a little bit about the conditions of Mr. Donziger's pretrial supervision. This morning, Mr. Kuby termed Mr. Donziger's conditions as, quote, extremely onerous. And to read Mr. Donziger's submissions, one would think that his conditions of home confinement are such that he has effectively been locked in his apartment 24/7 for the past 2 years. That is simply not true. At the outset of this case, the terms and conditions of Mr. Donziger's home confinement allowed him to leave home for family obligations, employment, legal meetings, religious services, and other types of activities approved by the pretrial services officer. And according to Mr. Donziger's pretrial services officer, he was quote, outside daily, quote, for a variety of activities, including walking his son to school and basketball practice every day, regularly going to the park with his son, attending sporting events such as baseball games with his son, going to the grocery store, and attending legal meetings several times a week. And lest you think he had to call 48 hours in advance for each and every one of those outings, that's not the case either.
That's not true. I've been with him.
The court also
when they
notes
deny
that for a meaningful portion of Mr. Donziger's pretrial supervision, due to the onset of the COVID-19 pandemic, all New Yorkers were ordered to shelter in place and essentially instructed not to leave their homes except for essential activities.
Yeah, it was COVID anyway, so it took him in house arrest unlawfully for 2
permitted
years.
him to leave for those activities as well, such as purchasing food, going to the pharmacy, attending doctor's appointments, taking walks outside with his son, etc. In short, the court is not trivializing the conditions of Mr. Donziger's pretrial release. But being able to remain at home, spend time with one's family, and meet critical obligations is simply not the same as being detained in prison pending trial, which is quite routinely the consequence of a criminal charge. Now,
not on a misdemeanor.
Confinement does not equal detention.
She doesn't even deserve
that
the title
understanding
judge.
is confirmed by the relevant portions of the U.S. Code. Under 18 U.S.C. Section 3585B1, quote, a defendant shall be given credit toward the service of a term of imprisonment for any time he is spent in official detention prior to the date the sentencing commences as a result of the offense for which the sentence was imposed, close quote. As the Court of Appeals has made crystal clear, a defendant, quote, is not entitled to sentencing credit for time spent during his release on bail, close quote. Martinez v. United States, 19F 3rd, 97, 99, 2nd Circuit, 1994, per curiam. That is true even if the defendant, quote, was placed under electronic monitoring and largely restricted to his residence, close quote. Notwithstanding that, quote, such terms of release on bail oftentimes may be rather restricted, close quote. United States v. Edwards, 960 F. 2nd, 278, 283, 2nd Circuit, 1992. that, of course, was not the case here. Nevertheless, the court may and does consider Mr. Donziger's time in home confinement. In that consideration, the court notes two things. First, Mr. Donziger's conditions of home confinement were relatively lenient, permitting him to be outside daily for family obligations, legal meetings, and other activities approved by the pretrial services officer. And second, as the court has already noted, the primary reason for the length of Mr. Donziger's home confinement was his numerous requests for trial adjournment. Now, as we've all agreed, in determining the appropriate sentence, the court considers the Section 3553A factors. Initially, the court notes that Sections 3553A 4, 5, and 7 have little to do with these proceedings. 4 and 5 ask the court to consider the guidelines range, which we've all agreed are not applicable here. Subdivision 7 instructs the court to look at the need for restitution, also not applicable here. Considering the nature and circumstances of the defense, of the offense, Mr. Donziger has sought throughout these proceedings and continuing to today to downplay the seriousness of his conduct. For example, Mr. Donziger and his supporters characterize his failings as a mere discovery dispute for which Mr. Donziger sought appellate review. CEG docket number 373 at 3. Mr. Donziger claims that 1, he did not ignore the protocol and discovery orders, close quote. 2, he actively engaged in the district court to modify the orders in ways that would protect the privilege of discovery, close quote. And 3, quote, he went into voluntary contempt to obtain a direct appeal, close quote. Sentencing submission at 4. The record in this case, apparent to anyone who takes the time and makes the effort to look at it, tells a different story. And I know that Mr. urged me to look at this case through the eyes of people the court has never met. Well, I say to that, it's also through the eyes of people who have never read the record here. And I join the special prosecutor in encouraging folks to read the record. If one reads the record, it will disclose a deliberate, willful, and repeated refusal by Mr. Donziger to obey court orders over a period of years. Let's see what happened. With respect to counts 4 and 5, recall that paragraph 1 of the RICO judgment imposed, quote, constructive trust for the benefit of Chevron on all property, close quote, that Mr. Donziger received or may receive, trace the Ecuadorian judgment.
Yeah, of course they want all.
And that judgment required Mr. Donziger to assign any such property, quote, forthwith, close quote.
Yeah,
Government Exhibit 1875, paragraph 1. Mr. Donziger received at least 2 pieces of such property. 1, a contingent fee under his 2011 retainer agreement. And 2, another contingent fee under his 2017 retainer agreement. In paragraph 1 of the RICO judgment even made clear by way of example that any rights to a contingent fee were subject to the constructive trust, and obviously within the order to assign those rights forthwith. The court found that Mr. Donziger acted knowingly and willfully when he failed to assign forthwith the 2011 contingent fee and the 2017 contingent fee. That's count 4 and count 5. Mr. Donziger does not dispute that from 2014 to 2018, he did not comply with paragraph 1 of the RICO judgment's directive that he forthwith assign the 2011 contingent fee, even after Judge Kaplan put him on notice that he would consider a contempt finding. Mr. Donziger only complied after a motion to compel was made, and even then he did not comply with all of Judge Kaplan's instructions. To make matters worse, after the entry of the RICO judgment that required Mr. Donziger to assign to Chevron his 2011 contingent fee, Mr. Donziger entered into a new retainer agreement for the 2017 contingent fee. He entered into that agreement after the RICO judgment was affirmed in full on appeal. Yet, he did not disclose that fact, the fact of the 2017 contingent fee, even though discovery requests clearly required him to do so. He finally disclosed the existence of the 2017 contingent fee in his June 2018 deposition. And it was only after Judge Kaplan found Mr. Donziger in civil contempt and imposed coercive fines on him did Mr. Donziger assign his rights to the 2017 contingent fee. Mr. Donziger's refusal to comply with paragraph 1 of the RICO judgment and failure to obey Judge Kaplan's subsequent related orders had absolutely nothing to do with protecting his clients or any claims of privilege. Indeed, it had nothing to do with anything other than Mr. Donziger's refusal to relinquish a potential personal payday for himself.
Okay, he
Count 6 related to Mr. Donziger expecting a portion of his contingent fee interest to a life coach in return for personal coaching services. Paragraph 5 of the RICO judgment explicitly forbade Mr. Donziger, quote, from undertaking any acts to monetize or profit from, close quote, the Ecuadorian judgment, whether by, quote, selling, assigning, pledging, transferring, or encumbering any interest therein, close quote. Government Exhibit 1875, paragraph 5. Mr. Donziger had acknowledged that paragraph 5 prohibited him from monetizing his interest in the Ecuadorian judgment, and he repeatedly represented to Judge Kaplan that he had never sold his interest in the Ecuadorian judgment. For example, Government Exhibit 2010 at page 26, lines 3 to 4, reflects Mr. Donziger's telling Judge Kaplan, quote, I'm not selling my shares. I'm selling my client's shares, close quote. But on December 23, 2016, Mr. Donziger entered into an arrangement with life coach David Zellman, under which Mr. Zellman agreed to provide coaching to Mr. Donziger in exchange for a portion of Mr. Donziger's contingent fee in the Ecuadorian judgment. Mr. Zellman confirmed that arrangement in the emails contained in Government Exhibits 105 and 106. In fact, in consideration for services provided beyond those originally contracted for, Mr. Donziger agreed to pledge an additional portion of his contingent fee interest to Mr. Zellman. Government Exhibit 110 shows that. Mr. Donziger never produced his emails with Mr. Zellman regarding this arrangement, even though those emails were responsive to discovery requests that Mr. Donziger had been ordered to respond to. When the arrangement eventually came to light in 2019, and Mr. Donziger told Mr. Zellman that the arrangement had become, quote, problematic, close quote. Mr. Zellman emailed Mr. Donziger that he was, quote, canceling our deal, close quote, thus putting the lie to Mr. Donziger's argument that Mr. Zellman's services were pro bono. Mr. Zellman confirmed on the witness stand that he did not provide or even offer any services to Mr. Donziger.
Yeah, just hold it. Yeah, I got it. Let that go.
Mr. Donziger.
Yeah, I think there's something wrong with the legs.
Waived a portion of his contingency to Mr. Zellman, despite his admitting that he knew he was not allowed to sell his own shares in the judgment. And again, this transgression has nothing to do with Mr. Donziger's advocacy, with his clients, or with any claims of privilege. With respect to counts 1 and 2, the court found that Mr. Donziger willfully and deliberately disobeyed paragraphs 4 and 5 of the March 5, 2019 Forensic Inspection Protocol. Recall that the reason for the protocol in the first place was Mr. Donziger's repeated stonewalling of discovery requests that he had been ordered to comply with. Paragraph 4 of the protocol required Mr. Donziger to provide sworn lists of his electronic devices and accounts to a court-appointed neutral forensic expert no later than March 8, 2019. Yet, Mr. Donziger did not provide any list relating to his devices until 3 months later, after Judge Kaplan had found him to be in civil contempt and levied coercive fines. Indeed, Mr. Donziger announced his intent not to comply with the protocol by saying that he would, quote, voluntarily go into civil contempt in order to obtain proper appellate review, close quote. Government Exhibit 133. With respect to paragraph 5, Mr. Donziger never, to this day, has surrendered any devices to the court-appointed neutral forensic expert. Indeed, you heard him today say that he would be delighted to work out the computer matters on the civil side. That's not up to him. Indeed, he does not dispute that he did not comply. He willfully and purposefully refused to do so, which he maintained was to ensure that he could achieve appellate review of the protocol. Yet, he never sought immediate relief from the Court of Appeals by way of a stay, mandamus, expedited appeal, or anything. When confronted with the opportunity to obtain the full appellate review that he claimed to have, quote, relentlessly, close quote, sought in order to protect his and his client's rights, Mr. Donziger passed. In absolutely no way did he challenge the lawfulness of the forensic inspection protocol, the passport order, or the contempt findings that flowed from those orders. Now, Mr. Donziger attempts to explain that by suggesting that his prevailing on what he terms his foundational objection, close quote, justifies all this. Foundational objection is his argument that all post-judgment discovery was inappropriate because the RICO judgment permitted him to raise funds by selling other people's interests in the Ecuadorian judgment. His argument is that that small finding undermined the entire protocol and the passport order. Indeed, Mr. Donziger asserts that, quote, while not overruling the other contempts, the Second Circuit's decision provides that all of the discovery orders and forensic protocols that were based in whole or in part upon the perception that Mr. Donziger was deliberately trying to conceal material information, require re-evaluation by Judge Kaplan in the underlying civil proceeding, close quote. That's in Mr. Donziger's sentencing submission at 5. That is categorically false. To the contrary, the Court of Appeals did not mince words as to the narrowness of its holding. It said, lest this opinion be taken as somehow vindicating Donziger, it is important to put our holding in context. Doing not in any way call into question the district court's thorough and fully persuasive law and ethics that added up to a pattern of racketeering in violation of the RICO statute.
And that's what Chevron should
Nor does it call conclusions that Donziger acted in contempt of the injunction that resulted from the RICO judgment in numerous ways. Indeed, except with respect to the very specific alleged violation of the injunction discussed in this order, and that's the part that prohibits Mr. Donziger, that allows Mr. Donziger to sell other people's interest in the judgment. Donziger does not even attempt to challenge the district court's findings of his contumacious conduct. Chevron Corp v. Donziger, 990 F. 3rd, 191, 212 to 13, 2nd Circuit, 2021. Moreover, the Court of Appeals that Mr. Donziger, from the date of the Court of Appeals opinion, was no longer authorized, quote, to profit in any manner from the sale of interests of any kind in the Ecuadorian judgment. At 212. Additionally, Mr. Donziger's felicitously titled Jenga Tower theory wholly ignores something Judge Kaplan explained to Mr. Donziger more than once. The post-judgment discovery proceedings were not limited to Mr. Donziger's alleged noncompliance with the RICO judgment. In fact, those proceedings also encompassed discovery requests in aid of Chevron's enforcing its money judgment against Mr. Donziger. In other words, there was another separate, distinct, and entirely permissible basis for the post-judgment discovery that Mr. Donziger did not ever challenge on appeal. As a result of Mr. Donziger's not challenging the protocol, the passport order, or any of the related contempt findings, the Court of Appeals affirmed Judge Kaplan's contempt findings almost in full. The only finding that was not affirmed, as I mentioned, involved Mr. Donziger's raising funds by selling other people's interests in the Ecuadorian judgment. But none of the counts of the criminal contempt in this case was predicated on those acts. Outside of that specific finding, the Court of Appeals remanded, quote, to the district court to determine the fees reasonably expended to secure the contempt findings that were affirmed on appeal. Yet, notwithstanding the Court of Appeals' clear decision, or as the court knows and as Mr. Donziger has admitted to this, he still has not complied with Judge Kaplan's order to surrender his devices to the court-appointed neutral forensic expert. And from Mr. Donziger's statement sentencing submission, it doesn't sound like he's going to do so anytime soon. Finally, with respect to count 3, Mr. Donziger willfully and deliberately disobeyed the order directing him to surrender all of his passports to the clerk of the court by June 12, 2019 at 4 p.m. That order had been added as a further measure to try to coerce Mr. Donziger into compliance with paragraph 5 of the protocol. That's the turnover devices paragraph. On June 10, 2019, at a hearing before Judge Kaplan, Mr. Donziger stated, quote, "I will voluntarily surrender my passport until I can deal with it at the Second Circuit," close quote. He did not do so. When Judge Kaplan denied his request for a stay and reminded him that he remained, quote, "obligated," close quote, to surrender his passport, Mr. Donziger still refused to do so. And he did not seek any relief from the Court of Appeals, despite his representation to Judge Kaplan that he was, quote, "immediately turning to the task of preparing an emergency stay to the circuit," close quote. Government Exhibit 2234 at 15 Note 6. In short, Mr. Donziger chose 1, not to comply with Judge Kaplan's order, and 2, not to seek any relief from the Court of Appeals. All of this is to say that Mr. Donziger's refusal to comply with court orders was not a one-off mistake. And it was not, as represented by Mr. Donziger in his papers and several of his supporters, it was not a mere discovery dispute. And it was not, as his counsel characterized it today, dotting I's or crossing T's, one of a handful of imperfect procedural decisions that he made, docket number 373 at 9, or simply a matter that should have been appealed, quote, "here and there," or mandamus sought, or the like. Mr. Donziger's conduct was a pattern of contumacious behavior that bore out over the better part of a decade. In our system of laws, it was the most serious offense. I now consider Mr. Donziger's history and characteristics. As for Mr. Donziger's criminal history, the court notes and the parties agree that he's never been convicted of a crime. With regard to his characteristics, the court has reviewed the numerous letters that were submitted on Mr. Donziger's behalf by his friends and colleagues. Many of these letters speak positively about Mr. Donziger's character and his commitment to his work in Ecuador and elsewhere. The court recognizes the admirable work that Mr. Donziger has undertaken in the past, including on behalf of those who are disadvantaged. But Mr. Donziger's good works do not excuse his years of refusing to comply with Judge Kaplan's orders. That defiance was no less willful in light of Mr. Donziger's past good deeds. With respect to the seriousness of the offense, the respect for law and just punishment. In a system of laws like ours, the refusal of a litigant, particularly a Harvard-trained lawyer, to follow orders of the court is most serious. Following court orders is the foundation of our legal system.
Tell us.
And it is all that separates us from trial by combat. Indeed, thus, Mr. Donziger's offenses are extremely serious.
You said that.
Given Mr. Donziger's repeated, willful refusal to obey court orders, It seems that only the proverbial 2x4 between the eyes will instill in him any respect for the law.
Wow. Wow.
The prosecution and the defense agree that promoting respect for the law is paramount in a case like this. But, as I said, his repeated refusals
Come on, spit it out.
seem to warrant a serious punishment. Deterrence. With respect to specific deterrence, the court notes that Mr. Donziger was not and still is not deterred by the coercive civil sanctions imposed by Judge Kaplan, even after he had an opportunity to obtain full appellate review. Indeed, he has not been deterred into compliance even today. So deterring Mr. Donziger from similar conduct in the future requires, in the court's view, a serious punishment. More broadly, many people, both lawyers and non-lawyers alike, believe fervently in their causes and might be tempted to refuse to obey court orders with which they disagree, as Mr. Donziger did here. Thus, a serious sentence is required to deter such persons from emulating Mr. Donziger's conduct. With respect to unwarranted sentencing disparities, Mr. Donziger is correct that the avoidance of sentencing disparities is among the factors enumerated in Section 3553A. What Mr. Donziger glosses over, however, is that the statute focuses on, quote, unwarranted sentencing disparities among defendants with similar records who have been found guilty of similar conduct, close quote. 18 U.S.C. Section 3553A6. Contrary to what Mr. Donziger suggests, other lawyers have been sentenced to prison terms for criminal contempt. As a special prosecutor noted, one attorney was sentenced to 3 months imprisonment for 3 times failing to appear in court. Rojas v. United States, 55 F. 3rd, 61, 63, 2nd Circuit, 1995. Another attorney was sentenced to 3 months for appearing late for trial and making misleading and incomplete statements to the court. United States v. John Meehan, 852 F. 2nd, 56, 57, 2nd Circuit, 1988. The Court of Appeals affirmed both sentences.
Human rights lawyer has never.
Moreover, other attorneys sentenced for contempt have received periods of home confinement as well as years-long sentences of probation, suspension from practice, and community service. United States v. Cutler, 58 F. 3rd at 832, In re Pollock, 07 MC 347 ARR, docket number 40. Mr. Donziger's conduct, which again includes years of refusal to comply with numerous court orders, is more serious than any of those other defendants' conduct. None of those defendants' disobedience occurred over so long a period or in defiance of so many court orders. None of those defendants' disobedience involved the degree of willfulness that Mr. Donziger exhibited, announcing to the world that he would not comply with the court's orders. Because of these differences, none of those defendants' disobedience struck so directly at the foundations of our system of laws as did Mr. Donziger's. And for those reasons, any disparity between Mr. Donziger's sentence and the sentences of those other defendants is richly deserved. In sum, Mr. Donziger has spent the last 7+ years thumbing his nose at the U.S. judicial system. It's now time to pay the piper. Accordingly, it is my intention to impose a sentence of 6 months imprisonment. Although a fine is authorized for this offense, it is my intention not to impose one. Because the court has already determined that the maximum sentence would be no more than 6 years, 6 months, or a $5,000 fine, the offense constitutes a petty offense. Under 18 U.S.C. Section 3559B, a period of supervised release is therefore not authorized because petty offenses are specifically exempted from the statute's coverage. See United States v. Donovan, number 04 Crim 1346, MHD, close paren, 2005 Westlaw 1322715 at Star 2, Note 4, SDNY, May 2, 2005. 18 U.S.C. Section 3013A mandates the imposition of a special assessment, quote, on any person convicted of an offense against the United States, close quote, open quote. Criminal contempt is a crime in the ordinary sense. It is a violation of the law, a public wrong, which is punishable by fine or imprisonment of both, close quote. Bloom v. Illinois, 391 U.S. 194, 201, 1968. And, quote, private attorneys appointed to prosecute a criminal contempt action represent the United States, close quote. Young v. United States, ex rel. Vuitton et B.S.A. 481 U.S. 787, 804, 1987. All of which is to say a special assessment is therefore mandatory. The special assessment to be imposed depends on the classification of the underlying crime. Because the court has already found it appropriate to treat Mr. Donziger's offenses as a Class B misdemeanor for the purposes of the sentencing guidelines, the court will use the same classification here. Accordingly, it is the court's intention to impose a mandatory special assessment of $10. See 18 U.S.C. Section 3013A1A. Counsel, is there any legal reason why such a sentence should not be imposed? No, Your Honor.
But for everything that we can say for a decade, putting that aside, no.
Thank you, sir. Very well then. Mr. Donziger, you're sentenced, sir, to a period of 6 months imprisonment. There will be no period of supervised release, as I mentioned, but you are also sentenced to pay a special assessment of $10, and that should be paid promptly. It's my duty to inform you that unless you've waived it, you have the right to appeal this sentence.
Maximum sentence?
Pursuant to the Federal Rule of Appellate Procedure 4B1A, any notice of appeal must be filed in this court within 14 days after the later of 1, the entry of either the judgment or of the order being appealed, or 2, the filing of the government's notice of appeal. Depending on your financial circumstances, you may also have the right to appeal in form of pauperis, which means as a poor person with the waiver of certain fees and expenses. Now, Mr. Donziger, I'm aware that you recently submitted a bail application at docket number 339. In response to your application,
Hey there, we good?
that the special prosecutors could respond, and they did so.
Hey there, it's Jordan. The judge, Loretta Preska, who, by the way, has ties to the Federalist Society, which is funded by Chevron, just sentenced human rights attorney Stephen Donzinger to 6 months in prison. With that, I think she thought she was being nice or doing him a favor by charging him a penalty of no more than $10, even though this man has been disbarred legally of his law license, so he could no longer practice law, has nearly been bankrupted by this crusade against him. So Stephen Donziger, on top of the 780 days that he has already served under house arrest, which this judge, if you were listening, tried to make it seem like it was a walk in the park and he could kind of come and go almost as he pleased, which is not true. She has now sentenced him to 6 months in prison. I know for a fact that they are going to appeal this, but I believe, I could be wrong, but I believe that they will be taking Stephen right after this hearing. I guess there's a wedding going on over there. I believe they will be taking Stephen right after this hearing, right into custody. This is obviously an outrage. This judge went on a long novel, really mischaracterizing the entire case. But I want to start, if you're completely new to this, Stephen Donzinger, along with others, was successfully prosecuted Chevron for poisoning the Amazon in Ecuador, poisoning their water with Chevron's waste from their oil, okay? People died, cancers. The indigenous people in Ecuador still have scars. This was the largest settlement in history against an oil company, $9 billion, $9.5 billion, that Stephen Donziger successfully prosecuted Chevron for. Instead of paying the settlement, they have gone on a holy corporate crusade against Stephen Donziger. Chevron, claimed that Stephen Donziger essentially paid off the Ecuadorian judge to get this ruling. There is no evidence for that, even though that this judge, Loretta Preska, who again has ties to Chevron, she has ties to the Federalist Society, which is funded by Chevron. She went on this long soliloquy saying that, well, the appeals court backed up Judge Lewis Kaplan's ruling that Stephen Donziger had bribed a judge. Well, that's just not true. Also, we should note that the original judge, Lewis Kaplan, who ruled that Stephen Donziger had basically committed fraud and under the RICO statute by bribing an Ecuadorian judge, he was invested in Chevron. I mean, you can't make this shit up. That judge, through J.P. Morgan, was invested in Chevron. He shouldn't have even been trying any case related to Stephen Donziger. He had investments in Chevron. He was asked to recuse himself and refused to. So that Judge Lewis Kaplan, I want to read a little bit more about that to you.
I think this valuable prosecutor may or may not wish to respond, but
The U.S. federal judge who ruled in favor of Chevron in the company's campaign to block collection of its $9.5 billion environmental liability in Ecuador held investments in the oil company at the time of his decision, documents reveal. Financial disclosure documents filed by the judge, Lewis A. Kaplan, show he invested in 3 J.P. Morgan funds that have holdings in Chevron. The judge never disclosed the investments despite being asked to recuse himself for bias in favor of Chevron. So this judge was invested in Chevron. It's a blinking red light, conflict of interest. And this judge, Lewis Kaplan, is who the current judge that just sentenced Stephen Donziger to 6 months in prison is referring to, that Stephen Donziger refused to comply with that judge's request for documents. What they were asking Stephen Donziger for was his devices, computers, phones, which had access to his communications with his clients. Well, under the legal system, what this judge keeps claiming she is defending and that Stephen Donziger has breached and has so vilely breached, according to this judge, well, under the legal system here, attorney-client privilege is private, confidential. By the way, Stephen Donziger not only didn't want to give up his devices, cell phones, laptops, etc., to the judge because of attorney-client privilege, but there were also communications about their strategies and plans for getting Chevron to pay that $9.5 billion settlement. So it's just the whole thing is half-assed backwards. I want to also read, this is from The Nation a couple months ago. There's been a news blackout by the New York Times and others which contrast their detailed reports on Donzinger from 2011 to 2014, when the oil giant prosecuted Donzinger and a few of his Ecuadorian allies from racketeering, using the Racketeer Influence and Corrupt Organizations Act, RICO, originally designed to pursue the mafia. Chevron, which had participated in every phase of the legal process in Ecuador, up to and including an appeal to that nation's highest court, brought an entirely new case in a New York federal district court to try to discredit Donzinger and his clients. Chevron, this is the most important part. Chevron's star witness, the star witness to claim that Stephen Donzinger had bribed the judge, was an ex-judge from Ecuador, Alberto Guerra, who testified that Donzinger and others had bribed him to ghostwrite the decision. Guerra's evidence was highly questionable. Chevron admitted in court that it had paid to move this Ecuadorian judge and his family to the U.S., and they rehearsed his testimony before the trial 53 times. Why would you have to rehearse somebody's testimony 53 times if they're telling the truth? That's not rehearsing testimony. That's getting them on script. That's giving them the testimony on what to say and lie about. So there was literally one witness to back up this claim that they just denied his bail, by the way. So Donzinger's lawyers requested bail while they appeal, and this judge denied that. So this one witness that Judge Lewis Kaplan, again, who was invested in Chevron when he made this ruling that Donzinger paid off an Ecuadorian judge, with that ruling, by the way, it let Chevron off the hook, which they didn't have to pay the $9.5 billion settlement, at least in the U.S. So Chevron pays to move this judge and his family. I think the number was between $1 million and $2 million to move him here. Then they rehearse 53 times, meaning give him the lie to tell. Then a Chevron legal maneuver deprived Donzinger of the right to a jury. So it was Judge Lewis A. Kaplan, again, the original judge, who in 2014, oh, by the way, Lewis A. Kaplan was a corporate lawyer, a tobacco lawyer, so we kind of know his background, turned federal judge, who in 2014 decided to accept this one witness who was rehearsed 53 times and find Donzinger and his Ecuadorian co-defendants guilty. Yeah, the judge who found Donzinger guilty of bribing an Ecuadorian judge, hence that they did not have to pay the settlement, who was invested in Chevron. I mean, you cannot make this up. You cannot make this up. Are you not listening to my live stream? That's what I'm saying. I don't know what the hell you're talking about. So, I'm live. Stop. So, basically, this would be the equivalent of if the judge right now prosecuting the former governor of Michigan, Rick Snyder, had donated millions to his campaign. That's what we're talking about here. I mean, it is blanket corruption, what is going on here. And by the way, the longest that an attorney in New York was under house arrest before Stephen Donzinger, who was under house arrest for 780 days, I think it was 90 days. So look at all the abnormalities in this case. You have, he was not able to face a jury. kind of unheard of. You not able to face a jury, under house arrest for 2 years, mandated to hand over his devices under attorney-client privilege, and now after 2 years and disbarring him, she's saying he has to pay the piper. He's saying he has to pay the piper. It's absolutely insane. Absolutely insane. So right now, Stephen Donzinger, I believe, will be immediately sent into custody. He's been denied bail. They will appeal it. I mean, this has been going on for over a decade. So I doubt that you're going to have much happen in 6 months. Let's show some of the speeches.
A social contract. Jean Locke, Jean Rousseau. Those are the philosophers from back in the 1700s that came up with that. Under that system, we surrender our rights to look out for ourselves. We surrender those rights to the government. In exchange, the government is supposed to take care of us. They're not supposed to favor the wealthy over the people, the citizens, the working class. It's supposed to be equal justice. It took a civil war to get the 14th Amendment. They have broken the social contract. There's no reason for us to obey orders from this court because they are illegal.
Yes.
And until and unless we do something very, very severe, like disobey their orders, and when they send out their forces of coercion, yes, they're forces of coercion, because these courts, they write on paper, but they have forces of coercion. U.S. Marshals, etc., FBI, federal agents, all the forces of coercion. And we see what they do. We saw that, unfortunately, that man being choked by a force of coercion. Until we say, no, we're not following your orders. Until we say, if you send out your forces of coercion, they will be met by our forces of coercion. Until we take back this country for the citizens, for the working people. We take it away from the rich, the Chevrons, the third biggest corporation in this country, I believe. How do you buy a prosecution? How do you buy judges? Until we say no forcefully with blood. And it's Thomas Jefferson that said, let the roots of liberty be refreshed by the blood of patriots and tyrants. That's Thomas Jefferson. That's what he said. Until we take it serious enough to do that, you're going to continue to breathe poisoned air, drink poisoned water, and be nothing.
That's right.
Nothing.
It's happening in this country.
Oh, it's happening in Pennsylvania, it's happening in Ohio, it's happening in West Virginia with fracking. They're injecting fracking waste right into the aquifers in California.
It's happening in Brooklyn.
All over.
It's happening in the Bronx.
Until we do something about it, more than just tweets, more than just Instagram, until we take it on the streets and take the streets like with George Floyd. Woo! Until we do something like that, this is going to continue. What do they have to do? Do they have to kneel on Stephen Donzinger's neck and choke him until we wake up, until we fill this street from a mile down that way and a mile down that way, until we fill it, until they're afraid of us? Until they're all afraid of us, nothing is going to get done.
It takes all of us.
Now, I didn't want to talk. I was surprised. I'm surprised they said all this. I guess I'm going to get in big trouble for it, but I don't care. If they come for me, Stephen Donzinger is a humanitarian. He's a peaceful guy. I'm not. Thank you.
Thank you. I knew you were going to be amazing. You're amazing. Thank you so much. Will you introduce yourself? Maybe you want to be.
Who was it that signed the Declaration of Independence with the big, big signature? Who was that? So that King George could read it. My name's Raymond Zupa. Raymond Zupa. I'm an attorney in the state of New York.
that shortly we'll see Stephen and his attorneys come out with his supporters. You're welcome to stay around. I don't know, until he gets cell service, I don't know if he's gonna come out this way. He usually when the trial or this is over, they usually exit on the other side, but he knows we're here. I'm gonna text him, call his wife, and see, because I think he deserves to speak in front of all of you with his attorney to let you know how he feels, what's to come. And I really hope that there's a way that we could all come in solidarity.
Hold on one second, guys.
Support him and his family, because they're just using him not to pay the judgment they lost in Ecuador in 2011. It was an $18 million loss. It went down to 9.5. They still haven't paid a dime.
So I don't know if Stephen Donziger is going to be coming out. She's saying waiting to hear from Donziger and his lawyers. I'm pretty sure he's going to go direct into custody. I hope I'm wrong. But, at the end of the day, what you're seeing here is a continued pattern of really what we've seen for the last decade or so, which is the criminalization of environmental activism, of a human rights attorney doing legal activism on behalf of poisoned indigenous people in the Ecuador. And by the way, Ecuador is not the only country far away that's being contaminated by Chevron, ExxonMobil, and all the other fossil fuckers. Okay? I mean, you saw what they did at Standing Rock. There are literally people who have been put in, environmental activists and indigenous activists, water protectors, who have been put in prison for basically banging on drums and dancing and singing at Standing Rock in protest of the Dakota Access Pipeline, who were railroaded through the legal system in North Dakota for protesting. A ticking time bomb of a pipeline going through their reservation, contaminating their water, contaminating their animals, digging up and desecrating their sacred burial grounds. We just saw Line 3, which unfortunately is now in operation. We just saw Line 3. Police literally, battering protesters. A story came out that police were using torture techniques on protesters they arrested. And now you have this charade. And it's really interesting to me. That if you were watching the judge's long essay before she sentenced Stephen Donziger, she said, this court has no interest, and this case is not about whether Chevron polluted the Amazon in Ecuador. Huh. Well, your friend, this judge who kept on mentioning Judge Lewis Kaplan, well, he seemed to care because he ruled that Stephen Donziger had bribed a judge in Ecuador, which there's no evidence for, and again, there was only one witness for, who essentially was paid off by Chevron to move him and his family to America, and had to be rehearsed 53 times before he gave his testimony on Stephen Donziger paying him off. It's unbelievable. Let's show you a little more of this.
A recent New York Times article about the fisherwomen that are, having to buy fish from Canada and other places because they've completely destroyed their life. They can't eat. They can't drink water. This is happening not just in Ecuador, it's happening all over the world. This is an American corporation that is getting away with murder. I am not exaggerating. Look at the report. There is case numbers. There is actual, information that you need, full names, witnesses, reports. There is all kinds of records of the kids and babies that have died because of Chevron. This is serious. This isn't, I love you, Stephen, for everything that you've given up and you've taught me. But this isn't just about Stephen. This is so much bigger than us. So much bigger than Stephen. I thank Stephen every day because I was in a deep slumber with what was happening. His case highlighted everything for me. And I'm doing everything I can to tell everybody I know about this case, about this global report by Dr. Nangrier, because it's the only way we are going to see the truth. We have to come together, we have to study and make time for these reports because they are killing our people, they are killing our world. If indigenous communities perish, we perish. We must protect the voiceless, the affected ones that are in the front lines of the Amazon and everywhere else. Trust me, this is a long, complicated case. It's layered, decades. There's been bribes, there's been all kinds of things by Chevron. The judge does not talk about that. How convenient. She only demonizes Donziger because Chevron brought him to court and sued him for $60 billion. I don't think an individual has ever in the history of this world been sued for $60 billion. And they dropped the charges to deny him a jury. So they literally bought their way into this court. The prosecutor, Rita Glavin, that just spoke before Judge Preska, she was just a partner in one of Chevron's law firms, Seward and Kissel. She worked for Chevron's law firm in 2018, you guys. She just started her practice on her own recently. So just think about the relationships, the corruption. She has had, apparently it's been disclosed that she has had secret meetings with Chevron. That's unconstitutional. They denied this man, this human rights lawyer, a jury. They denied him public Zoom access to silence his case, which every other case got. She forgot to mention that in her lengthy comments. She silenced Stephen's case. People all over the world, they want to know what's going on with this case. It's an international case. She silenced his case. Nobody else did that in this court. They all got public Zoom access. They froze his accounts. They disbarred him. They want to destroy this man. They want to destroy his family. But I know Stephen because now he's my friend. He is strong, but he needs our support locally here in New York. He really does, especially now that we know his fate. And I hope they come out and tell us legally if there's any hope out of the 6 months. By the sounds of Judge Loretta Preska, I don't think there is hope. But I am looking forward to his attorney's legendary Marty Garbus, who I highly recommend. Also, you research his work spans. He's an author. He's an amazing human rights attorney. Like they shared before, he represented Mandela and many more, the Cuban Five, historic cases. I would love to hear from them after this. I hope they know we're here. I might have to go on the other side to make sure. But this is so much bigger than what's going on today. And that's what I want to make sure you all understand. I wish Dr. Nangrier was here so that she can talk about the forensic report she wrote? Because I wanted to like print it out and digitize it, because Stephen's case is just one little case in that report. This is not okay. The U.S. government, the Biden administration, Merrick Garland, DOJ, Stevens begged DOJ. He's begged Merrick Garland to take this case and review it. Why? Because what they're doing to him is so unconstitutional and so unlawful. We must talk to everyone in our community about this. We must share the report far and wide. I am counting on every journalist that's here to review this report and write about it, because the public deserves to know about these international human rights crimes and violations. I already listed them earlier, but if you're new and you haven't heard, it's torture, it's slavery, it's kidnappings, it's rape, it's murder. Literally, Chevron hired a militia in Niger to kill an innocent protester. They partner with corrupt governments around the world and destroy communities and their environment. They're over there on the other side? Okay, but, okay, so we gotta go because I guess they're on the other side.
Hold on, folks. We're going to try and move this around. We're carrying heavy equipment, so bear with us. Follow us. Follow us. So I assume Stephen Donziger's attorneys are on the other side speaking after this sentencing. So follow us. Live internet. And guys, this reporting isn't cheap, so if you could support us, we've been covering the Donzinger case for months, in addition to all the other reporting that we do in the field. So I hope you'll consider becoming a member. StatusCoup.com/fall. StatusCoup.com/fall. We are doing a fall member drive right now. So if you sign up as a member today, you'll get free Status Coup swag. T-shirts, posters, all that good stuff.
You're missing the fifth item. The item was last week. You missed the scanning again. It's in the
So everybody everybody needs to be here.
Try not to have a bullhorn in front of your face. Good, thank you.
Okay. Can everybody see me?
Yes.
Yes.
Okay. Can everybody hear me?
Yes.
Do I need a microphone?
It's on, it's on.
Do I need a mic? Does microphone help? Yes, it does. Yes? No? Microphone doesn't help, sir?
Not for me.
Even louder! All right. So the Judge Preska and the fascist Chevron Corporation can hear our voices? Like that? Okay. There we go. Okay, well, I mean, look, any day when we walk a client out of the front door of the courthouse is a good day.
given the nature of criminal charges. A lot of you saw that correctly that Judge Preska had largely written out her decision in advance and largely read from it. That actually is not unusual in sentencing cases as a general matter. And in this case, it was an absolute inevitability. The outcome that you saw today was preordained and predestined as soon as Judge Lewis Kaplan ended up on the first discovery motion after Chevron came back to the United States complaining about the courts in the venue of Ecuador where Chevron fought so hard to be. All of this has been a very, exciting television series, but we've all known the ending. And this season finale of Demonized Donziger, brought to you by Chevron Corporation, this is over today. There will indeed be a next season. Look, I pretty much said everything I had to say in front of the judge. None of this is surprising. The fact that it's not a surprise makes it no less vile and unjust, improper, unprecedented. But it's not a surprise. And look, the only thing that would have changed today's outcome is the one thing that was never ever going to happen, which is for Stephen Donziger to stand up and say, I'm sorry. I'm sorry I took on Chevron. I'm sorry I spent my whole career litigating against one of the parastate like the Chevron Corporation. I'm sorry I didn't jump through every single hoop that was put in front of me at the precise time and distance, and then grab the American flag, wrap himself up in it while tearfully singing the Star-Spangled Banner, because that's what these people think the rule of law is about. So I'm going to go. I've got an appeal to work on, just so you understand the procedural aspect of what happened today. It's my understanding that Judge Preska has agreed to allow Stephen Donziger out and under his current conditions, provided appellate counsel within a week file an application for expedited review of her decision on the motion for bail pending appeal. To be clear, she always found Stephen Donziger a risk of flight, which we always said was ridiculous, that Stephen Donziger came back from Canada when he faced the possibility of felony charges. He came back here and has complied with all conditions of his release. Sort of ridiculous to think Stephen Donziger is going to flee New York City, leave his wife and child, his whole life behind, become an international fugitive while committing a felony in the process so he can hang out in some village in Ecuador. That was always ridiculous. It's just as ridiculous now. And so we have, I hate to express confidence, but there is a reasonable possibility that the Second Circuit is going to keep him out on bail pending appeal, and should, while his appeal is heard. Because otherwise, he will have served his entire sentence before his appeal is heard. And if you think about that for a minute, that, of course, is perfectly consistent with everything else that's happened in this case, right? Okay, I got to go to work.
Can you wait for a few minutes? Stay out during the appeal?
I'm sorry?
If the appeal is followed in the week, does he stay out?
That's up to the United States Court of Appeals for the Second Circuit.
I think this is, to be clear, there's two appeals. Okay? There's an appeal of the conviction, which is going to take 1 to 2 years. But what they were talking about today is an immediate emergency expedited appeal on whether I can stay out pending resolution of the big appeal. and to avoid the situation where I might have to serve the entirety of the 6 months, and then if I later win my appeal and get exonerated, I would still have served the sentence even though I'm not guilty. So usually, especially in misdemeanor cases, it's almost unheard of, correct me if I'm wrong, Ron and Marty, but it's almost unheard of for a defendant not to be allowed to stay out pending resolution of his appeal in a misdemeanor case. So this is very unusual and, you know, disappointing. How do you feel right now?
Mr. Donziger,
Can you hang on just
I'll
for a
be
little
very
bit longer?
brief.
okay.
The appellate papers have already been prepared. They will be filed Monday. Well, everything here was predicted. I opened the case when we tried it. I said there would be a conviction. And I said at that time, this is in May, that there would be the maximum sentence. So there were no surprises. What she chose to ignore was a very important document from a man appointed by the New York State Bar Association to look into the case. That man heard days of testimony. He saw Steve on the stand. He saw Steve's accusers on the stand, not hidden behind any particular criminal case. And Mr. Horan, a very respected lawyer, as I said, appointed by the New York State Bar Association, sent her a letter on Thursday saying that he should not be given any additional time, that he has been punished greatly, and Judge Horan, the referee rather, in the Bar Association proceeding, determined and wrote about the credibility and decency of Stephen Donziger and the justice of his cause. I recommend that you read the report of referee John Horan, appointed by the state of New York, which directly contradicts everything that Judge Preska said today.
The judge said that Mr. Donziger, that you ought to be hit between the eyes with a proverbial 2x4 for continuing to refuse the court's demands. How do you feel about the 2x4?
I think the whole idea of violence, which comes out with that, really tells you what is driving this thing.
Can your client answer that?
Hey, look, I will take the hit between the eyes with the fucking 2x4 if we can just be done with this already.
Steven?
Go ahead, Stephen.
I think, look, today is very, very disappointing. In my mind, it's a complete injustice. And let me explain what I mean. You know, Judge Preska went to great lengths to read a pre-written decision outlining what she claimed was my contumacious behavior over a period of 10 years. Okay. I reject all of that. Every one of those incidents she described, I was litigating, and she basically, and Judge Kaplan, have determined or have decided that litigating the issues somehow amounts to contempt of court. And you heard that again today, when my lawyers are litigating this very case, filing motions, and she's holding it against us for even trying to litigate these cases. So, you know, I've been targeted for 10 years by a demonization campaign financed by Chevron, carried out largely by Judge Kaplan. Jeannie Mirror, who is an esteemed lawyer in New York and a friend of mine, wrote with a bunch of other lawyers, 200 lawyers, signed a 50-page misconduct complaint against Judge Kaplan, outlining his abuse of power and targeting of me, which I would encourage everyone to read. Jeannie actually wrote it. Maybe you want to say a few words. But there's two just completely irreconcilable views of what's going on here, okay? Their view, we reject completely, okay? It's just not what has gone down. There's an interpretation for everything. I have complied with hundreds of court orders. I've been targeted probably with the most well-financed corporate retaliation campaign through the law in American history, and I'm still standing. I've never been convicted of a crime with a jury. I was just convicted by Judge Preska without a jury, and you can see her attitude, you know, so I'm comfortable in my own skin with our position, although terribly disappointed with the sentence today. But, you know, this is all designed to silence this campaign to hold Chevron accountable on behalf of Ecuadorian indigenous peoples. They don't want me speaking anymore. And what better way to do that than to put someone in prison for 6 months? I mean, it's an intimidation play. You know, and there's never been an attorney, I'm sorry, for this level of misdemeanor without a jury who's ever been sentenced to prison for contempt, okay? And now I'm the first, not only that, I'm getting the maximum sentence. So I'm disappointed, but we're not giving up hope. As Ron said, we have an appeal about the immediate issue of whether I have to go into prison prior to the resolution of my appeal. We have a fabulous appeal on the larger issue led by the Zuckerman Spader law firm, Professor Stephen Vladeck, Nathalie Segovia of the Water Protectors Collective. I believe she's here somewhere. Nathalie, where are you? Come in here so people can meet you. You know, Nathalie is part of the appellate team, and we have a really good appeal, and we're at least mildly confident we're going to prevail on appeal, and I'm going to be exonerated. And the question is, can I stay out until that appeal is fully resolved?
What message do you have for shareholders
all over the world now?
Roger, come in here.
This is no longer a local issue.
Roger, get in there.
You're a fossil fuel prisoner.
This is no longer a local issue for the Southern District of New York. You know, Prescott today kept reiterating what happened in the RICO trial, and I was sitting there like that, desperate to stand up, call her a liar. In court, obviously you can't, because then they'd lock me up too. So Stephen and I could...
We can't afford that.
No, but what I'm saying is that this movement that started to support Stephen and to fight Chevron in all their disgusting machinations by hiring these two appalling federal judges in this building here, Kaplan and Prescott, okay, they are going to find their match, and their match is in Stephen Donziger, but it's also in the rest of us. The rest of us will stand shoulder to shoulder. We're not going anywhere. If you want to fight on the ice, here we are. We're all putting our skates on, as they said in court today. You know, the RICO trial I was there. I watched it. It was a complete put-up job. Now, the question I want to ask is, when it went to trial to appeal to the second circuit, I've never been able to understand why the appellate judges were not allowed to hear the testimony that said that the chief witness for Chevron in the RICO trial was a man called Guerra, who lied through his teeth. He was paid $2 million by Chevron to lie in court, and that fact has never come out really in general public. And it's super important. It shows that that was a kangaroo court, and this is a kangaroo court as well. But we're not going anywhere. This choir will sing at the top of its lungs until we get justice, not just for Stephen Donziger, but for the people of Ecuador, the people whose lives have been destroyed by the only responsibility that a corporation has is in its bottom line and to its shareholders to maximize their profit. Well, that, as we all know, is insane. It's law in the United States of America, corporate law, and it's wrong.
Some people all over the world are watching what's happening. Do you have the feeling it's saying something about the trends in America, all over the world at this moment, and what's happening in America today?
By the way, that's Laura Haim, formerly of Canal Plus from France. Thank you, Laura, for the question. Look, I think this is a very poor reflection on the United States embarrassment for our country, that we are now becoming one of those places that locks up its human rights lawyers. That's what we have become. It's no different than Russia, China, Saudi Arabia, Hungary, and so many other countries. But the world always saw the United States as a bastion of a judicial system that actually adhered to the rule of law. And what I've learned through this particular case is when you challenge entrenched interests to such a degree that they feel a level of risk of the type that Chevron feels, which is a multi-billion-dollar risk, they can actually have the power to capture parts of our federal judiciary. Chevron has captured these judges. And you know, one thing that was not mentioned today, and should have been, is that the prosecutor, Ms. Glavin, was appointed out of a Chevron law firm after the regular federal prosecutor declined to prosecute me. Okay, so what's that all about? And you know, and the sanctimony, I mean, think about it. I'm violating all these court orders. Well, you're actually conflicted. I mean, you're not any normal prosecutor would have never brought this case, which is why they refused to bring the case. So why is it that only a Chevron private law firm is actually prosecuting me? I mean, this is the first corporate prosecution in U.S. history, and trust me, that is the playbook that the fossil fuel industry has created to go after activists, and it's a very poor reflection on the United States of America. In my mind, completely undermines any moral authority that the Biden administration might have to criticize the human rights record of other countries.
Right. Attorney General. Right. Have you contacted him? Have you gotten a response from the administration which says it will be directed and led by concern for human rights?
I'm very disappointed in the Biden administration and Merrick Garland. 6 congresspersons, including Jim McGovern, Jamie Raskin, AOC, Rashida Tlaib, Cori Bush, Jamal Bowman, signed a letter in April directed to Merrick Garland, my understanding, asking him to intervene and take back this private prosecution from Chevron. My understanding, he has not even responded to the letter.
Not to mention that tons of letters have been sent in by everybody.
So, look, it's never too late. I don't understand how the Attorney General of the United States, who perhaps his highest duty is to uphold the rule of law in this country, allows a private prosecution to take place run by a Chevron law firm, directed not just at anybody, directed at the guy who actually won the big civil pollution judgment against Chevron. So that is not how it's supposed to work. Again, I believe it's an embarrassment for the United States.
Stephen, they made it seem like your house arrest is kind of been like this walk in the park, like you've been able to come and go as you please. I mean, I was just there. It doesn't seem that way. There seems to be a personal disdain the judge has for you, in basically describing it like you have not really suffered here.
Do you want to answer that?
She compared it to the pandemic, and that you were just.
Let me just address that briefly. It is certainly been true that the probation department has permitted Stephen to spend time with his young son, provided there's advance notice and provided things are worked out properly. And that's a true thing. The rest of the time, however, he has been prohibited from engaging in normal human activities that are an indispensable part of liberty. To walk down the street, to simply go to a park and sit there in the park, to show up at a demonstration. In one case, he wasn't even permitted to leave his home, to walk downstairs and walk across the street to address demonstrators who were there in his support. This 2 years of detention has essentially incapacitated Stephen as a human rights advocate, which frequently involves traveling to places for meetings, for conferences, meeting with affected and frontline and indigenous communities, and it has prevented all of that. These remain, home detention with an ankle monitoring device is the most serious imposition on liberty short of actual incarceration itself. It's written there in the bail statute. So the fact that she's allowed him to go to a ball game with his son is lovely, but it's been 2 years of this.
Contributions to the Legal Defense Fund still go to the name on the website?
Yes. If people want to help, please contribute to the Legal Defense Fund at freedonziger.com.
I gave it the office.
Weekly appeal, how long do you have to wait for their possible decision?
Okay, now we're sort of in the area that as a general matter, if Stephen will first be appealing Judge Preska's decision to deny him bail pending appeal. So that appeal must be filed on an expedited basis within 7 days. The prosecution then responds, and the court hears that in its own good time. Simply because we request expedition doesn't mean the Second Circuit will see Stephen as the urgent flight risk that apparently Judge Preska does. So they may very well take an extended period of time. Separately from that, Parallel but non-intersecting is the appeal of the criminal convictions and sentence which is imposed today. Notice of appeal must be filed within 30 days. There's a briefing schedule, but essentially it's likely it will be at least a year, if not longer, until the ultimate appeal of the criminal case is decided.
Have you thought about designation if it comes to that, where you would ask to go? The MCC actually is not fully closed down. Joshua Schulte is still there. There are a number of inmates still there.
Are they accepting new candidates, or are they just? I don't think.
Yeah, they haven't put any.
Yeah, they're not, right. I'm sorry, I misspoke. They are closing it down. They're not accepting any new arrivals. There are no mints on the pillow of the Epstein cell. And they're moving everything to the MDC, which historically has been even more poorly run than the MCC. So there is really no acceptable place for in our carceral system for somebody with such a low security classification, such a low custody classification, and such a short sentence.
And the reason, if I may add, is because people at my classification level, it's so low for this kind of petty offense, almost never get sent to prison. So there's no like it's not even mention anything in the sentencing guidelines about it. So, you know,
we're going to probably build a prison just for you, Stephen.
Yeah. Well, we'll be there for you every step of the way outside your wherever they put you.
I'm thinking
when will
the bracelet come off? When will the ankle bracelet come off?
The ankle bracelet comes off when he goes to jail. Yay!
Steven, amigo, el pueblo está contigo.
Thank you,
Steven, amigo, el pueblo está contigo. Steven, amigo, el pueblo está contigo. Steven, amigo, el pueblo está contigo. Steven, amigo, el pueblo está contigo.
Thank you, guys. Marty Garbus wants to say a few words about putting this in historical perspective. Marty, who's represented people all over the world in difficult conditions.
I've represented Nelson Mandela, Daniel Ellsberg, Václav Havel, Andrei Sakharov. Tested the limits of government and the characteristics that they have, that commitment not to let governments push them around. Mandela did 27 years in jail. Havel did 4 years. And an extraordinary, significant figure. When Dan Ellsberg came to end the Vietnam War, I said, A, it will not end the Vietnam War, and you will go to jail for your life. Good for all of us, he ignored my advice. There are a lot of people whose courage comes up to the level of Steve Donziger. He belongs in that pantheon of people who can do nothing other than what they perceive to be right. And when you talk about the names I have just mentioned, these are people who did the same thing and suffered, some of them, very severe punishments. So I think that what's happened here is Steve has started something that it's going to go on for the next 20 years. Steve is going to become the lightning rod for all of this. And one of the questions is, what can the people do to help him? One thing you can do is stop buying Chevron products. One thing you can do is start boycotting Chevron products. One of my clients, Cesar Chavez, did a national boycott of grapes, for those of you who remember that far back. And he was eminently successful. The question is, Stephen has done what he has done. What are you going to do?
That's right. The people must come together.
Thanks, everybody. You know, we'll be in touch. Are there any more questions about anything?
What about
Has Chevron come? Stephen, has Chevron come after any other of the law team?
Give me 1 second. It's because I have a question right now. What's your question?
There was something said in the courtroom about attaining new counsel. Can you speak to that a bit?
Oh, the question is new counsel. There's a new group of lawyers coming in to handle my appeal. They're from a law firm in D.C. called Zuckerman Spader, and they're joined by Natalie Segovia of the Water Protector Legal Collective and Professor Stephen Vladeck, who teaches at the University of Texas Law School. He's a constitutional scholar. So there's 4 lawyers who are going to be handling my appeal, which, by the way, even though this is a misdemeanor case, she wrote 250 pages. It's a relatively complex, technical, quite intellectually interesting appeal that we have at least mild hopes we will prevail on. So that's the new legal team, but they'll still be assisted by Mr. Garbus and Mr. Kuby. But, you know, in the law, appeals cases are technical and they're different than trial cases. So usually bring in lawyers who specialize in that. That's what I'm doing.
I'll just say one thing, Stephen, if I may. What we saw today was something that we expected, and we've been ready to fight from the minute that we walked in the door this morning. Usually as attorneys, whether it's trial attorneys or on appeal, we take our cue from our client, from the person that we represent. We don't even like, personally at the Water Protector Legal Collective, using the term client because it reinforces clientelism and corporate issues that are part of the problem at the root of this case. So Stephen is someone that we work with and someone that we will represent. And Stephen's willingness to fight has not been dampened at all today. And so we will take that cue and we will continue to fight for Stephen and for justice. Not just for Stephen in this case, but also for the accountability that Chevron pay reparations, that it actually pay the costs that it was ordered to pay by a Supreme Court judgment issued many, many years ago now, and that the indigenous peoples and rural communities of Ecuador have yet to see justice, have yet to see accountability. What we've seen in Stephen's case, somebody asked, I believe a reporter from France asked about what this says about the rule of law in the United States. What this says about the rule of law in the United States is that we believe ourselves to be the city on a shining hill, that we believe that we are an exception to the rule. We are not an exception to the rule. In fact, today Judge Preska said we need that she was ordering, and that the order was for specific deterrence, so that people would no longer emulate the actions of Stephen Donziger, so that young attorneys would not want to be like Stephen Donziger. I can say that we take our hat off to Stephen Donziger because he is the quintessential human rights lawyer. He is an attorney through and through in every sense of the word, and a human rights advocate. Whether he started like that or not, you know, is a question that perhaps someday you'll ask Stephen. I've had the pleasure and the honor to speak to Stephen on many occasions, and I can say, as a person, his heart and unwavering commitment is to the people and to the communities that he's served. He saw injustice firsthand and decided to do something about it. I have next to me Paul Pasimino, who has been an incredible advocate for Stephen, but also for the communities via Amazon Watch. And one thing that we see over and over again in the global south and across the world is that there is no justice for indigenous communities. There is no justice for those that are marginalized and that live at the outskirts of the world. And this case has shed light not just on what is happening to Stephen, but what is happening across the world with impunity. And so we will continue to fight because that is what Stephen has asked us to do. That is what he is resolved to do. And his resolve is what we take our cue from. And so I believe Ron asked, you know, are you sure you want to be part of the appellate team? We're not fighting. We're not running from a fight. And neither is Stephen. And so we will continue to do that. And because Chevron needs to be accountable for its actions, we ask that you all continue to stand with Stephen. You continue to support the way that you've done so. And thank you all for being here today.
We charge you with genocide. Chevron, Chevron, you can't hide. We charge you with genocide.
As Natalie mentioned, I'm with Amazon Watch, and I do want to tell you one thing. This is not happening in a vacuum. This case is taking place, it's unfolding in a point in history when we, the people, need to stand up to the fossil fuel industry, aggressively destroying our planet and our climate for a profit. And the reason that we're here is that when we win, they strike back. But it cannot end that way. We have to stand with Stephen so that others like Natalie follow and do the same thing. If they're allowed to silence him, we have no hope of fighting back and achieving climate justice. And the problem is we've seen that the judges are in their pockets. We've seen that they have no shame in the face of the European Parliament, Nobel Prize winners, the entire human rights and environmental community, now the United Nations. Judge Preska said she will take the decision for what it's worth, and then dismissed it, and then turned around and made a joke essentially about hitting Stephen in the head with a 2x4 after she's been identified as a human rights violator. So please continue to press your representatives to contact the Biden administration and force them to respond to the United Nations before this appeal is done, because they must step in and take the case back. And as Stephen pointed out, they can do that at any time.
So I think we're going to break. If people have more questions, you can ask them maybe individually. Thanks to everybody for coming out. I know there's a lot of journalists here, but also a lot of supporters. Thank you so much. We'll continue telling you what is in store next. This is not ending anytime soon. It probably will never end. So today was just one day. It was expected, and you know, the good thing is they showed their hand. You know, we have some sort of resolution now, and clarity as to what the true intentions were of this whole exercise, which is to put me in jail without a jury. And we'll now go forward with the appeal and see how that turns out.
Stephen.
Yeah.
Stephen, in the 145-page indictment over the summer, she said it was time for you to pay the piper. I read it. It really reeked of like some personal animosity towards you. And then today, it seemed like she had been working on this for a long time. Like this was not something she just decided in the recent week. The key thing that stood out to me is she was reading from the appellate decision to prop up this claim that you had paid off an Ecuadorian judge, but she kind of left out key details like, Mr. Waters said that they had rehearsed that one witness 53 times. They paid for his family to come over, that Judge Kaplan himself had ties to Chevron. It just seems like there's a lot of personal animosity here that I've never heard in a misdemeanor before.
Well, there is a lot of personal animosity by Judge Preska and Judge Kaplan and Chevron. I mean, they're angry that I think they're angry for various reasons. Fundamentally, that I help indigenous peoples hold a large American company accountable for massive environmental crimes in the Amazon. I mean, they don't want an American lawyer, particularly one from their world, who went to Harvard Law School doing that kind of work. They're angry. You know, they're almost angrier at me than if I had actually taken a pickaxe and murdered 10 people. I mean, I really feel that. They're really angry at me. And I think it's ideologically driven, and I think they're abusing their power. You know, so this treatment of me is totally disparate. You know, 787 days on house arrest for an offense where the longest sentence ever given is 90 days is disparate. It's discriminatory. It's selective, and it's wrong. So, you know, what she attempted to do today was justify these abuses of power by clothing them in technical jargon and making it look like there was some legitimate legal reason to do this, and we reject that.
Do you think on the wider scale, you look at what happened at Standing Rock, what's been going on at Line 3, basically trying to criminalize environmental activism, and now, you know, legal activism. There's been laws attempted in states to criminalize or let people off if they run over protesters. All of this is happening under, a Democratic administration. What are your thoughts on the role of Merrick Garland, Joe Biden, who said a lot about Trump's attacks on the law?
Well, I think the Biden administration, and the Department of Justice need to step in and take back the prosecution from the private Chevron law firm and conduct it professionally, responsibly, consistent with legal ethics and the rule of law. They haven't done that. You know, they're weaponizing the law to attack an activist, which, as you know, is part of a trend in the United States. Natalie can speak to that. It's happening in my case. This is a significant, even egregious illustration of that trend, which has now begun to really penetrate our legal system in ways that, frankly, should terrify anyone who believes in the rule of law and free speech in our country. Because our country is under serious threat from corporate control of our courts and our laws that punish the heck out of people who take on the fossil fuel industry. And I'm part of that. That's why this is happening to me, fundamentally. You good? Yep. Okay. Thanks, everybody.
Thank you.
I need to collect my sign.
Jamal. So, sorry to say, folks, but our battery is about to die. I think we've been live. We did 2 live streams, one from a rally before Stephen Donziger went in today, and obviously after his sentencing. It's really, what's going on here is a continuation of what I've been seeing on the ground reporting for 6 years now, and that is the complete corporate takeover, a corporate hijacking, not only of our courts, our government, and that hijacking of our government's been going on for 30, 40 years. I mean, look at what's going on right now in D.C., where you have 2 senators bought off by big pharma, fossil fuels, big coal, et cetera, basically hijacking, even the most modest social welfare programs in Kirsten Sinema and in Joe Manchin. The media won't mention, by the way, the money they're taking for their obstruction. You have the corporate takeover of the courts, the corporate takeover of the government, corporate takeover of the media. The New York Times has not covered this story. The Washington Post, I've barely covered this story. CNN, MSNBC, the Associated Press. We could go down the list. I mean, Chevron is a pretty well-known company, don't you think? Ecuador and environmental contamination, it's a pretty important topic, don't you think? They've barely covered the Flint water crisis. They covered it for 2 weeks 5 years ago when Rachel Maddow went down, and then they fucking forgot it. And it's been left to me. I've been there 18 times in 5 years because no other media outlet will cover it. So they don't care about the poisoning of American citizens. They certainly don't give a damn about the poisoning of indigenous people in Ecuador. And this continues. And if you really listen to this judge's, whatever the hell she was reading from, there was this mentality of, no, it's not Chevron or the corporations that have to pay the piper. It's not Chevron or the corporations that are killing people that need to be hit by a 2x4, is what she said. It's human rights activists. For what? For what? Because he wouldn't hand over his laptops? He wouldn't hand over his cell phones with his attorney-client communications? The whole premise of going after him was a charade that this man, a human rights attorney, by the way, with no other criminal convictions, with no legal record to speak of, that he bribed a judge in Ecuador? The evidence? One witness, an Ecuadorian judge who they paid $2 million to come from Ecuador to the U.S., and they rehearsed him 53 times, meaning they trained him on how to lie 53 times before giving testimony. It's just a charade. And I think, as Stephen was saying, and I've been saying, this is about much more than just Stephen Donziger. I mean, today is about Stephen Donziger, obviously. But this is about, we've become the United Corporations of America. I've been saying that for years. We don't live in a country. We live in the United Corporations of America. And frankly, this kind of thing is going to continue. Oil companies, fossil fuel companies are going to continue ramming their pipelines through native land. They're going to continue dumping their waste on indigenous land, in communities with poor black people, in communities with poor brown people, in communities with poor white people, from fossil fuels to mining, the mining that they're doing on native land, until people do more than just tweet. And that's why I've been calling very loudly and very proudly for a year now. We need to start working towards economic boycotts. You're not going to get real change. You might get little things here and there through politics. You need economic boycotts of Chevron, of Amazon, of Walmart, of the fast food industry, of the big banks. Not everybody could do it, obviously, but it's terrible. How much time do we have?
It says 13%.
13? Hey, Greg. Can I speak with you? with the legendary Greg Palast in from California. You've been following this case avidly. Yeah.
Guys can see me.
Legendary independent journalist, done great work specifically on voter suppression in Georgia and all over the country. I mean, you've covered it all, much more than me.
I covered Ecuador. I was down, and I documented the destruction by Chevron for BBC Television Newsnight back in 2007. So I've been following this for 14 years. And I found documents showing that Chevron, Texaco unit, the president of Texaco, personally ordered the destruction of documents showing that Chevron Texaco had dumped sludge in the indigenous areas. I mean, they literally said, remove the documents and destroy them. Destroy them is their word. So, and so I've been somewhat shocked. Now, obviously, this appears to be retribution against a human rights lawyer, and kind of throwing his body out on the tarmac as an example, so no other law student, graduate of Harvard, is ever going to say, yeah, I think I'll do that because I'll lose my law license, I'll go bankrupt, they'll throw me in prison, all for defending indigenous people. Now, I have to say that before I was a journalist, I was for 2 decades an expert on racketeering for the Department of Justice and Attorneys General in the United States. I worked all over the world, actually. And I have to say that as the Department of Justice expert on racketeering, I've never seen a case like this. The racketeers are usually the bad guys, not the human rights lawyers. And the judge was acting like she was sentencing Willie Sutton for bank robbery. As she herself noted, no lawyer has ever been sentenced to 6 months for contempt in American history. In fact, it's not clear that anyone's ever been sentenced to 6 months for basically a dispute over procedural matters. It just doesn't happen. Going to prison for 6 months, no jury trial. And the guy's already been ruined, had his license pulled, he's bankrupted, and they wanted to go through his laptop and cell phone. If the court ordered me to do that, I couldn't do that either, not ethically. That endangers the lives of his clients, the indigenous people. They're already dying from this stuff. I was there. You have to go there and see it. In fact, if you go to gregpalast.com, you can see some of the footage from BBC television that... and I got to tell you, people covered with pustules, and, you know, it was the evidence, and again, I used to be an investigator for Justice Department, it was solidly clear that this was Texaco's oil. There's no question about it. The Ecuadorian courts had trials for several years, scientific evidence. I spoke to Chevron's lawyers, and I asked them about the childhood leukemias that were found by the experts. They said, oh, well, is this the only nation in the world that has with kids with cancer? And you'll never be able to prove that that oil causes cancer, which, you know, I mean, most scientists, biologists I don't know if they would laugh at it, they'd be horrified. And they said, and then try to prove it's our oil. You know, oil looks like oil. Well, who else was drilling there? So, it's clear that they will spend anything. In fact, Chevron itself says that their legal bills have hit over $1 billion to go after Donziger. $1 billion to go after one man. He feels honored. I am very stunned at this procedure. Again, I've been in many federal courtrooms for the Justice Department as the expert in racketeering cases, and I've never seen conduct like this. And I really want to know where the official U.S. Justice Department is. We have this odd situation in which you have a kind of Chevron-connected lawyer acting as prosecutor against a human rights lawyer. Under Merrick Garland, we have a new Attorney General, new president. The Justice Department should take control of its own case because, after all, this is a Justice Department case, and even Trump's people wouldn't touch it. And so the judge handed it off to a private attorney. This is very unusual. It's a very dangerous procedure. The United Nations Human Rights Commission has said this is a very dangerous procedure. I'm very concerned about how this is operating. Very concerned.
What does it say? I mean, you've been covering corruption throughout the country. Yeah. I mean, I call it the United Corporations of America. They've bought the judges. They've bought the government. They've bought the police. I mean, what does it say? I mean, you've been covering corruption throughout the country. I mean, I call it the United Corporations of America. They've bought the judges. They've bought the government. They've bought the I don't know what other way to say it. You have police in Standing Rock and Line 3 brutalizing protesters. Now you have Chevron financed or friendly judges doing things like that. What should people think about this is supposedly a democracy?
Well, this is a new level of danger where they're actually going after the attorneys. For those who remember the Chicago 7 trial, which was just, made into a movie, yes, the Ron Kuby, who is Steve Donziger's lawyer, his predecessor, his former boss at his firm, William Kunstler, was found in contempt of court over 40 times. But, they gave him a couple $1,000 fine. And that was considered a major miscarriage of justice. Sending an attorney to prison over a legal dispute where he's trying to protect indigenous people, and she made it sound like he was making all kinds of money off this case. The guy has worked 38 years. He's worked over 3 decades on human rights cases, over 3 decades on this one case. And I can tell you, I was just interviewing him in his house. It's his little dinky apartment, which is completely paid for by his wife's salary. So there's a guy who graduated from Harvard Law with Barack Obama. I saw them photos together. And instead of cashing in, he decided to help people who couldn't help themselves, who couldn't defend themselves. And she's acting like he's just stuffing his pockets with money. What money? It's like, look, you have to respect the rule of law. But the judges need to respect the rule of law. I've seen some, frankly, in the U.S., we have some bad judge behavior. I've seen it. Nothing like this. And that judge, when she talked about contemptible behavior, the way she was acting, using phrases like that this lawyer deserves a 2x4 between the eyes. I mean, excuse me, this isn't exactly Judge Judy. This is, it's just like, and you almost felt like if she had the 2x4, she would love, in her hand, she would love to administer judgment, and that she almost felt frustrated that she had agreed that there would not be more than a 6-month sentence. The only reason they did that is to deny Steve Donziger a trial by jury. Most Americans think if you're going to stand a chance of going to prison, you get a trial by jury. Not if it's less than a 6-month prison term. So they denied him a trial by jury. Just as, I think as that most Americans, if they were in that courtroom, and in the courtrooms in the cases leading up to this, would be stunned and horrified. And, and they go after everyone. Frankly, I want to admit that, and I want to disclose, Chevron went after me, after Greg Palast. When I reported, I went down to Ecuador, got the evidence against them, and they filed a complaint to try to get me fired at BBC. I had to go through hearings myself, my own trial, and then BBC found that I was impartial, fair. I gave a completely impartial, fair report. In fact, Chevron's biggest complaint, that I let their lawyers talk too much on camera. I mean, they hung themselves. And I asked them to explain the documents showing that they had destroyed evidence, which in the U.S. is a go-to-jail crime. That's obstruction of justice. That's not a misdemeanor like with Steve Donziger. It is a felony crime. I want them to explain this document, smoking gun, showing that they had committed a felony crime. And they said, well, we'll get right back to you. That's been 14 years. I'm still waiting for them to get right back to me, Chevron. So I'm going to go to the Justice Department now and find out why they're not involved in justice, why they have basically privatized the prosecution of an American citizen, that's a first, and that's very, very scary business.
Thanks, Greg.
You're very welcome.
GregPalast.com does great work. Thank you. So we're going to have to wrap up here because our battery is dying. We've been covering this pretty much for months. I just interviewed Stephen Donziger in his apartment last week. We covered protests happening outside Stephen Donziger's apartment with Susan Sarandon. Roger Waters was there. We cover a whole lot of things if you're new to us. So please, if you can, this is not cheap. It costs a lot of money, camera people, the trips that we travel for, flights, hotels, food, equipment. We don't take corporate money. That's why we are able to cover this, because we're not bought by the corporations. I'm sure they'll come after me at some point. So if you can, right now we're doing a membership drive. So go to StatusCoup.com. Fall, F-A-L-L. We're doing a membership drive, so if you sign up as a member before October 31st, you'll get free swag. So Status Coup posters, T-shirts, sweatshirts. There's a whole lot of stuff up there. StatusCoup.com/fall. You can become a member for as low as $5 a month. That's 16 cents a day. Believe it or not, there actually are journalists covering real things, but it takes money to do so. That's why the majority of journalists cover bullshit and do propaganda 24/7. So StatusCoup.com/fall. Our membership drive is underway. I think we're about to hit 1,800 members, paid members. We want to get to 2,000. So if you got $5 a month, please consider StatusCoup.com/fall. Become a member for as low as $5 a month, and you'll get some free merchandise. Thanks for watching. We'll keep covering this. Have a good day. Oh, thanks, man. I watched your show. Oh, thanks.